The Royal Commission is now in session. Please be seated.
Thank you. Ms Hogan-Doran.
Commissioner, may I just raise a housekeeping matter in relation to transcript access? There are delays in provision of transcript to parties, and what I understand is that the process is at the end of the day's hearings, a draft transcript is made available by the provider to the Office of Solicitors Assisting. There is a 2-hour window in which any corrections can be made, and if done within that time and returned to the provider within that time, the transcript can be released of an evening. Otherwise, it goes over to the following day, and sometime during the course of the day, the transcript becomes available.
I wonder if there's any reason you couldn't get a draft, but is that what you're seeking, or?
Well, Commissioner, it may be that internal processes can be done so that it could be released to all parties of an evening rather than just to the Commonwealth.
Okay, I'll see what I can find out about it, Ms Hogan-Doran. Yeah, it's not quite the same. I'm just informed that you've got access to real-time transcript, but it's not quite the same as having it at the end of the day.
And it's only available, as I understand it, on the monitors that are present in the hearing room.
I don't think it's the same.
And I did inquire in relation to that. And the an alternative solution may be that a first review is done and then released, subject to any further correction that is made. We would be seeking to provide corrections if it's required, and there may be other affected parties who may appear next week that may wish to have access to transcript in a timely fashion.
Look, it's not obvious to me why you couldn't get it in draft, but there may be things beyond my understanding. So can you just leave it for the moment? I'll get the solicitors have heard what you said. I'll see if we can get some sort of response later.
Yes.
And we'll move on with the day. Your appearances are all the same?
Yes, they are. Yes, they are, Commissioner. And I've made some arrangements, subject to your convenience, with respect to the additional tender list of additional documents that have been brought to our attention overnight. And I'm seeking urgent instructions in relation to those that affect the witnesses that follow Mr Hirschhorn.
All right, thank you. So am I still not... You said something yesterday about there being a document in respect of which there might be an issue, or documents?
That's been resolved by way of redactions.
Okay.
And so the documents that have been exhibited so far have been subject to redaction. I think there was even some examination on that particular document yesterday.
Okay.
There are documents that are in the proposed tender bundle for today, at least one of which attracts parliamentary privilege. We've had some discussions about how that might be handled without it needing to go into evidence in that form. It may be that we can, in the time available, have a redacted version prepared. It's document 491.
Right.
Just trying to put in an efficient way of dealing with these kinds of additional documents that are raised overnight that fall from the either the production or the evidence of the witness. I appreciate that Council will identify additional documents during the course of examination. And
well, I've got a list of additional documents that go, it's anticipated, from Exhibit 488 to 505. Can they be tendered now, or do you want to wait until the...
So the list I have, Hearing Block 1, Day 7, tender list draft, commences at 488 and finishes at 504 with respect to Mr Hirschhorn, and then there's the other witnesses.
Yeah, there's 505, I thought probably went in at this stage too, which is guidelines, data matching guidelines.
It's not on my list, Commissioner.
Okay.
Perhaps you have a more advanced version. But 491 on your list?
Sorry?
Document number 491.
Is the one that you're worried about. can it be given an exhibit number is all I'm asking really. Can I make these things exhibits subject to the modification you're talking about?
So I can let it be tendered. Yes, yes, Commissioner.
Thank you. Do you want to tender 488 to 504 on this draft list?
Yes, I do.
Gregory? Very well. So these are additional documents emanating from the tax office as I understand it. The first being a DHS information request and the last being follow-up advice. They'll be numbered 488 through to 504 in accordance with the schedule and subject, I gather, to some modification of 491. Thank you.
Yes, thank you. Commissioner, Mr Hirschhorn resumes in the witness chair today, and I might start with one of the additional tender documents because it continues the chronology. Exhibit 499 ATO.002.079.0228. Now, Mr Hirschhorn, broadly speaking, there were some additional documents which came through after I think your statement was prepared and made their way ultimately into, some of those made their way ultimately into the bundle that has just been marked as exhibits. And this is one of those of which you were aware at least at the time you made your statement, even though production might have occurred at a later time. That's right?
Council, I'm not immediately familiar with the document.
Right.
I have seen a lot of documents.
No, that's okay. All right, well, we'll work our way through it. If we go to the bottom of the page, it's the start of an email from Nicole Elsmore, 24 May 2016, to Gail Hopley within the ATO. And it relates, it's the follow-up from a telephone conversation referring to Elisa from General Counsel, and that is the General Counsel office which you described yesterday, who had asked for further information on the query regarding data sharing as part of the whole of government debt initiative. And what was set out there was a request to review some information and modify and expand as required. There were 4 questions. What kind of information will be shared? And the answer seemed to be information on individuals' debts to the Commonwealth. Which agency or agencies do you wish to share the data with? The answer was DSS and DHS. It was two-way sharing, and the purpose was for services delivery to undertake a pilot data sharing program to test the proposed design. And there was a reference in the final paragraph to a meeting between DSS and Treasury tomorrow, that being the Wednesday the 25th of May 2016. Although you've reviewed a lot of documents, you understand that this was in respect of the online compliance initiative in a broad sense, related to...
That would be my reading of the email.
Yes. So if we return then to the first page and the first email, the response from Lisa Carley to a number of people within the ATO sets out some broad propositions which related to the ATO understanding in respect of its obligations about data sharing. And these are described as preliminary points, of course. It's not suggested, I don't think, that this is a comprehensive advice, but if you just might take a moment to read that to yourself.
Yes, Council.
Yes. The second paragraph, if the information we would disclose to other agencies is not identifying information about a particular taxpayer, then the secrecy provisions don't apply. That's the effect of it.
Correct.
And pausing there, what you described yesterday was the process by which the ATO matched identities of taxpayers for the purpose of provision to the Department of Human Services under the proposal due to commence on 1 July 2016.
Yes, so Council, I would say that that paragraph is trying to distinguish between our ability to share information in relation to the tax system,
Yes.
which is unconstrained by the taxpayer secrecy provisions,
Yes.
and in distinction to information which would be identifiable in relation to a taxpayer which is subject to the confidentiality provisions.
And going back one step further, what you described yesterday in terms of broadly the data match program was the role played by the ATO in firstly identifying the person by reference to their taxation information or information held by the ATO for the purpose of the data match process.
Well, so yes, Council. So the provision of the data back to Services Australia is a provision of information in relation to specific taxpayers.
Yes.
And so is at a first level would, in the absence of an exception or a requirement, would be in breach of our taxpayer secrecy rules, but then due to the existence of a specific permission in the Tax Admin Act, or indeed under the DMP, a compulsion to share, that is how we could share that information.
Yes. And so in the terms, or rather in the language of the second sentence, identifying information was what was in effect to be shared by the ATO with DHS under what became the Robodebt scheme.
Yes, indeed.
Yes. And the broad proposition identified in the remaining paragraphs distinguishes between two categories of identifying information. The first is that the ATO can disclose taxpayer information for taxation purposes, that is to achieve the ATO's ends, and there are provisions around that. And the second is the disclosure of taxpayer information or identifying information to other agencies for their purposes,
Yes.
which is identified in the second paragraph.
Indeed.
And I think, as you just indicated, there are exceptions to the general secrecy provision that was identified yesterday, and what was identified in that second paragraph is a specific reference to those exceptions to the secrecy provision, particularly section 355-65 in Schedule 1 of the Taxation Administration Act.
Yes.
And again, in terms which are identified in the first dot point, taxpayer information or identifying information could be disclosed within that exception for the purpose of administering social security law,
Yes.
insofar as we're concerned with in this inquiry.
Yes.
And what was identified by Ms Carley at the end was that the key to all of that is what kind of information would be disclosed, and it's clear that it is identifying information in terms of what preceded these questions. The purpose for disclosing it necessarily must have been for the purpose of administering a social security law, and to which agency we would disclose it, identifying the difference between policy agencies and related service agencies because of the language of the need to provide for a purpose of the administration of a social security law.
Indeed, and that within this framework, in a sense, that once there is a permitted sharing, it is a permitted sharing only for the purposes of that law.
Yeah.
And so we're very careful to only share the necessary information, which may be at a different degree of granularity for an administration, a service delivery agency, which will need more detailed information, and a policy agency, which will need less detailed information.
Precisely. But in respect of either agency, a policy or a service delivery agency, what regulates the extent to which information can be shared at all, and then in what detail, is that it must be done for the purpose of the administration of social security law.
Yes.
We go to Exhibit 477. Now this is an email 2 days later, 26 May 2016. ending 0503. I should say the last email is 2 days later, but it starts in April. I might provide the full number, although it may be that some redactions are being undertaken on the run. Exhibit 477, ATO.002.077.0503. Thank you. If we can just go to the second page, 0504 at the top, there's no need to call out the box or the table which falls in the second half of the page, but it is sufficient if the introduction to the email is called out. It is an email from Tim Bergen to the General Counsel requests, again that section within the ATO that you identified yesterday. The subject is DHS exchange more granular IITR data in DMP. Now you'll recall yesterday that there was an ongoing conversation through April which continued after this event about whether data could be shared under the Data Management Program Act, and that was resolved as a no, and that's why things progressed outside of that Act. But at least this is the context in which this email was sent, and it was identified that the next key date regarding this item is 10 a.m. Friday, 22 April, when SES sponsors from both DHS, that's Mr Britton, and ATO, Mr Holton, will re-meet to discuss specific data extraction, and weekly meetings were occurring. What followed then was a set out of fields of potential data which was being then exchanged under the Data Management Act, and we go then to page 0506 and pull out paragraph 2 at the top. What was identified there is the transition you described yesterday, in which we ultimately which the ATO ultimately received advice in respect of, which was the TFN issue under the DMA legislation, and the move from that compulsion, as you have identified, to provide tax information to the guidelines, although if that could be put back in the next paragraph pulled out. Thank you. That data would be obtained outside the Act and instead be obtained by applying the guidelines on data matching for the Australian Government Administration, that is the voluntary data matching guidelines. We go then to the bottom of the page, key dates, which simply gives us some sense of the chronology. The second dot point, and this of course was in April, relates to the ATO needing to commence data extraction to meet DHS requirements, and that the date was already critical, which is why the SES were meeting, but there might be some wriggle room. But EST, which I understand to be effectively the IT section of the ATO, was pressing to commence extraction immediately following the SES meeting on Friday the 22nd of April. You mentioned yesterday, I think, that data provision under the bulk data program provided by the ATO to DHS occurred periodically throughout the year during the Robodebt scheme.
Yes, my understanding it was a biannual process.
And by particular months or upon request?
Sorry, Council, I don't know. I think it was periodic, but I don't know.
All right. But twice yearly in large volumes?
Yes.
The suggestion here is that data extraction, at least from the ATO side, was to start soon after the 22nd of April. Have you been able to identify from your preparation whether that occurred?
So my understanding is that shortly after the program started, there was a special bulk data extraction of the previous years.
All right. And you mean after 1 July 2016?
Look, I think it was after 1 July.
Have you identified?
I'm not.
You're not.
I'm not sure.
All right. But at least it hadn't happened by the 22nd of April. It happened. The first bulk data extraction occurred sometime after that.
Yes.
And potentially in advance of the 1 July date.
It may have been. I don't know.
Now, if we go then back to page 0503, the first page on the document, at the bottom of the page there is the reference to General Counsel and a reference to Ms Felton's advice, which I think we identified yesterday. One of the questions that had been returned was about some of the fields in the data which was to be provided, which I think you described yesterday as some tweaks needing to be made in the provision of data outside the Act to the fields that were provided under the Act.
Yes, so I think there were two challenges. There was the potential change in the data fields to be provided, as well as the more significant change, which was the change to the identity matching process.
Yes. And if we go then to the top, the advice that was received from Ms Felton was copied to Ms Carley, who had 2 days earlier identified the broad scheme that we went through in the first exhibit for today. And the advice was this, which again reiterates that exception to the secrecy provision, the purpose of administering a social security law when it's put there in specific terms. There is a reference in the second paragraph to the AGS advice that was written in a context that DHS advised the ATO they did not need to know when fields were 0. Do you know anything about that advice?
I do not know. I've not cited that advice. My interpretation of the substance is that there would have been, well, it's referring to some advice that although taxable income may have been relevant for the purposes of the Social Security Act, if somebody had a tax loss, that would not be relevant. So we would not provide them with the tax loss because that would not be for the purposes of the Social Security law.
And that understanding that you have obviously identifies the end point about the use to which the information would be put, that is the ultimate purpose of it.
Yes, so that is my interpretation of that, which is that only the fields which were relevant in relation to that individual could be provided under that exception.
And specifically within the purpose to which the information was to be put.
Indeed, because if it was not within that purpose, it would be a breach of taxpayer secrecy.
The final paragraph, if the taxation officer is satisfied that the protected information requested by DHS is for the purpose of administering the Social Security Act, 1991, the information can be provided to DHS. How was it that from the ATO perspective, the ATO satisfied itself that the protected identity information was for that purpose? As in, what steps did the ATO take, to your knowledge?
So again, not having been part of the decision in relation to this is referring to a specific data field or expansion of a data field, not to the provision of information in its entirety. In terms of the overall process, we provided information in relation to an individual. If Services Australia, they provided us a list of their clients that they were seeking information in relation to, which if we then identity matched, we provided that information. The fields we provided, conceptually, the taxation officer who originally made the decision would have to have been satisfied that they were relevant in relation to their rules. I'm not aware of exactly how that satisfaction was reached.
What was clear, even though that highlighted paragraph related to a specific field which had been reduced to zero for taxation purposes in the number of fields of information generally provided, was that nonetheless, once one stepped outside of the Act into the voluntary guideline space, that someone had to reach a degree of satisfaction that it was for the purpose of administering a social security law.
Yes, in order to fall within the exception, a taxation officer would have to have been satisfied that the particular information fields, well, can I say, relevant for that individual, but also the particular information fields were relevant for the purposes of administering a social security law.
And moving then from that hypothetical or abstract general proposition to specifically in respect of the data provided under the voluntary program or the voluntary guideline by the ATO to DHS, have you identified who in the ATO satisfied themselves that the bulk data exchange was for that purpose?
I have not identified a formal document evidencing satisfaction. The relevant area of the taxation office would have been the smarter data area of the taxation office.
Right. Would you agree with me generally in respect of the ATO's provision under the exception for the purpose of administering social security law, that it was either a legal question, that is, it was administering a law, or at least a question of mixed fact and law, because it involved the end use to which the data was being put within a legal construct of administering a law?
Look, I would agree in that there is a question to be answered as to whether it is relevant for the purpose of administering a law, which would presumably have both legal and factual elements.
Yes. And would you agree what flows from that is that the obvious way in which the ATO could satisfy itself that the bulk data transfer was not a breach of its secrecy provisions was that it would obtain legal advice either internally or externally to identify that the move out from under the Act to the voluntary guideline was lawful?
Yeah, that is, I would agree that is one way that an officer could satisfy themselves.
Yes.
Another way may be to rely on, because in a sense we're talking about a law administered by another agency.
Yes.
Generally we would rely on the other agency in relation to the operation of their law.
On that topic, in force at this time, and we know that we're only about 5 weeks out from the start date of the scheme, the Legal Services Direction 2005 was in force at the time, as I understand it, and Section 10.8 of the Legal Services Direction provided for an agency who obtained an advice relevant to the conduct or business of another agency would be encouraged or expected to provide that advice, in broad terms.
Yes, my understanding of the guidelines is that the default position is that the agency who administers the law is the one responsible for getting legal advice. Another agency, if they wish to seek their own advice, must do so in consultation with that other agency. If I may
Certainly.
expand, from my review of the documents of the time, because the fields were the same as those that had always been provided, I think much of the communication, the internal communication, is on the assumption that because it has been used by Services Australia for so many years in the administration of their laws, it continues to be relevant to the administration of their laws.
And what might be overlooked in that assumption is the change from the obligation to provide the information under the Data Matching Act to the different situation where the ATO volunteers the information under the guideline.
Yes, I agree that there is a theoretical potential for some of that information to be compelled under one, but not be relevant to the administration of the law. That would seem strange, but I agree that there is a theoretical possibility of there being a mismatch.
And the difference comes down to the role played by the voluntary disclosure of information under the guideline and what is required under the Act.
Yes.
And so far as you've identified, save for the exchange of the advice by DHS to the ATO about the tax file number question, which we dealt with yesterday, were you aware about whether the DHS or indeed DSS provided the ATO with any advice it had obtained in respect of the purpose to which it proposed to put the ATO information?
I'm not aware of any advice that was obtained at that time or provided to us.
I've now found the note about section 10.8 of the Legal Services Direction of 2005, and it is in these terms that where an agency, a particular agency, which all of these are, receives legal advice and considers it likely to be significant to the other agency, it is to take reasonable steps to make advice available to those agencies. A whole of government approach, essentially, in respect of relevant advice between agencies is contemplated by the section.
Yes, that is my understanding.
Yes. If the ATO had at this point, that is May 2016, when it's focused on this broader question about the purpose to which the bulk information is to be put, if the ATO was informed by DSS, the policy parent department, that it had internal advice which didn't support the use proposed by DHS of the data, what would be the ATO response to the provision of data?
So if we were aware of advice that said that the data was not relevant for the purposes of social security, we could not provide the data.
And given what we've identified as a legal question, that is, for the purpose of administering a law, that plainly, from the ATO perspective, contemplates the administration of a law in accordance with the law.
Yes.
If we move forward to 2019, we know that there were various declarations made in the federal court in Ms Amato's case, which related to the invalidity of the assertion of a debt based on the ATO information, that is, the use to which it was put by DHS. We have the class action, and on Monday this week the Solicitor General's advice was tendered, and I think it was on Wednesday we heard that the SS had obtained an advice from Clayton Oots in draft form for what that is worth, which lined up as well. What you're saying is that if the ATO was aware of those advices in May 2016, it wouldn't have provided the data.
Yes, so,
Sorry, aware of the legal position identified in those advices at this time.
so the first thing I would say is that we were not aware of those legal advices.
Yes.
Look, it's beyond my expertise as to what would happen if the information was for a good purpose and a bad purpose. I suspect that if it was relevant for a good purpose, it would still be able to be provided, even if it was also used for a bad purpose, but that is beyond my expertise. But certainly, if we were provided information that it was not being lawfully used, that would be something that we would consider very deeply, because we would be very worried that we would be breaching the Tax Administration Act.
And while at least the Legal Services Direction casts an apparent onus to take reasonable steps on the agency with the advice, to share it, in this case with the ATO, undoubtedly the exception to the secrecy provision casts an onus on the ATO to satisfy itself, as we've identified in the email trails from the General Counsel's office, that the purpose is the administration of a law, a social security law.
At least that a purpose is, yes.
Well, the purpose for which it is provided, irrespective of what other purposes it might be applied to, but so long as the ATO is providing it for that purpose.
Yes. I agree, yes, although we would approach that question assuming that another agency is operating on a lawful basis.
Of course, a reasonable assumption, although in circumstances here where there was a shift out from underneath the obligation provisions of an Act to a voluntary process, and in respect of a high volume of taxpayer information, have you been able to identify any request by the ATO to either DHS or DSS to validate that assumption?
No, I've not identified any communication from any request from the ATO. From reading the documents, the assumption was that the information specified under the DMP was relevant for the purposes of administering social security law. Indeed, why would it be in the DMP if it was not? And thus the focus was on the changes of information to be provided, not the core information to be provided.
My point is the change between the obligation to provide the information under the Act and there being no obligation to provide the information under the guideline. That's a critical distinction though, isn't it?
It is an important distinction, and as I said, there is a theoretical chance that some of the information specified in the DMP may not be relevant for administering a social security law, but the assumption from my reading of the documents at the time, the assumption of all the officers was that if it had been specified in the DMP, it was specified because it was relevant for the purposes of administering a social security law.
As I understand what you're saying, there was no additional steps to address that difference between the obligation and the voluntariness in the context of the purpose to which DHS proposed to use the information.
Yes. Yes, so I note your point, and I have not identified any analysis of that point.
We could turn to Exhibit 255. This moves forward to 30 November 2016. if I just go down to the passage under heading General Discussion, this is a point at which some emails within the ATO described a spike in complaints being received by the ATO due to DHS compliance activities. And from your review of the documents, you were able to identify that in November 2016, December 2016 and early 2017, this was a hot topic.
Yes, so from my review of the documents, starting in November, going through December, there were more complaints coming in.
Yes. And what was sought here in this email from the ATO to Mr Lumley at Human Services was a more general discussion to understand the process at the DHS end, which might be related to the spike in the complaints that the ATO was receiving.
Yes, that's my reading of the email.
We can go to Exhibit 478, ATO.001.957.1405. This email trail reflects the discussion on an ongoing basis about what information DHS was putting into its material in respect of the letters that was being sent out and effectively attributing the information to the ATO rather than its own analysis or use to which the information was being put.
So that is my understanding from reading the emails, yes.
And the suggestion partway down the page was instead of we received the data from the ATO, which directed ultimately complaints in an indirect sense to the ATO, it was suggested that there be a reduced focus on the ATO by different language, which said we received data from the ATO that they received from an employer's PAYG lodgement, which identified in a more accurate fashion the nature of the information provided by the ATO to DHS.
Yes, that's my reading of the email.
Yes. If we then go to the top of the page, the issue that seems to be identified here was described as some systemic issues with the way DHS is utilising ATO data, and a meeting was proposed with Mr Lumley from DHS to discuss, and there were other complaints that would be good to raise if that meeting eventuated. From your review of the documents, what were the systemic issues that were understood in this context?
So I'm not sure what this email is referring to specifically. A couple of issues that are in the correspondence at around this time some are around identity matching.
Yes.
And by moving away from TFN to a name, address type identity matching, there were some issues where a person's income was attributed often to a family member. So there was an example in the email correspondence of a mother and daughter with the same name living in the same address. There was another issue where the information was matched. A CRN was provided to us as part of that matching. which was somebody else's CRN, a family member's CRN. We returned the information to Services Australia, and they attributed that information to the actual owner of the CRN rather than the family member provided to us. So there are a couple of identity matching issues which are referred to. My understanding is the numbers affected by those was very, very small. I suspect, given its proximity to the earlier email, this may well also be, or may instead be referring to the fact that DHS is representing, in a sense, how it is representing the strength of the ATO data in its correspondence with individuals. These issues, in the email correspondence at this time, all of those issues are swirling around. Indeed, this email may be referring, it may even be referring to something else. I could not identify from the correspondence.
One example of that is Exhibit 259, if that could be brought up, ATO.001.0635.1611. This was a discussion at 3 or 4 weeks later, 20 December 2016.
Jess, do you have a complete set of exhibit lists? Do you have the earlier exhibit list? Oh, no, okay.
The subsequent pages to the email identify a conversation between various people which relates to identity, and in some of the examples that you give, for example, the mismatch of identities between family members. But if we go to the first page of the document, again, this is an email internally within the ATO where there was information about media attention with the DHS program, the Robodebt scheme, and there are links to a number of online media reports from various news agencies, commencing with The Guardian at the top and others thereafter. And then we go to the question of systemic issues. Where, thank you, some more detail is given. As it was understood by the ATO at this time, undoubtedly from information from DHS, that once the identity matching process had occurred as described in the first paragraph, DHS were attaching the income details, that's the PAYG summaries, to their client record without further validation, and undertaken discrepancy matching resulting in the correspondence being issued. That is the question about whether there had been an overpayment, or the request at least to update and identify or confirm the information that had been provided by the ATO. And then there goes on to identify that the identity issue relates to customer reference numbers, which are internal numbers allocated to customers of social security recipients. And then, in fact, the DHS contact centre personnel had been telling people who rang up about, in response to the letters, that they needed to resolve the problem with the ATO.
Yes, Council, this is the issue that I referred to just before, which is that we were providing information in relation to one person who was accurately identity matched, but then because we were reattaching the CRN that we had been provided, and it was somebody else's CRN, Services Australia were matching the income of person A and putting it in the discrepancy matching or the process for person B.
We turn then to Exhibit 260, ATO.001.635.2663. A couple of days later, again, an email between Mr Brown at the ATO and Mr Lumley at Human Services, copying in Mr Fawcett from the ATO. And again, a reference to media attention surrounding the DHS compliance program and the fact that that was attracting our SES, the media attention the program is attracting, our SES are questioning whether the ATO has any exposure. What do you understand to be meant by the phrase exposure in this context?
Yes, so my interpretation of this email is that there was media attention, there was reference to the fact that ATO data was being used. My interpretation of the email was that SES, so that's Assistant Commissioner and Higher, would have been concerned that we were sharing data inappropriately with Services Australia, so worried as to whether we were meeting our legal obligations.
We can turn to Exhibit 481, ATO.001.924.1910. We've moved now to early January 2017. And there's a reference to media articles which are attached in the first line. The second paragraph refers to Karen, who appears in the emails, Karen Ernst. Karen has also been through DHS's DMP in protocol and highlighted that we, the ATO, are highly exposed as the matching agency, and below are some extracts from the document that highlights this. The full protocol is also attached. Now, this was a protocol developed, it seems, between DHS and the ATO in respect of non-employment income data matching. To the extent...
So it appears, so Council, I would say it appears on its face to at least be the DHS. I don't know how it was prepared. It appears to be the DHS's document. I'm not sure how involved the ATO was.
All right. I may have
I suspect not very, because I don't think the ATO would agree that we were the matching agency.
Right. I might have over-assumed from the apparent title of the document in the list of attachments, but in any event, the significance of it is that there were various parts contained in the document which refer to the ATO as the matching agency, the primary user as DHS, data mechanisms and the like. And particularly towards the bottom of the page, there are two sentences, one commencing following and one commencing when a customer. The information at this point within the ATO's knowledge is reflected, the information in respect of the purpose of the administration of social security law to some extent is reflected in what is contained in this email within the ATO. Firstly, there's a reference to the provision of matched records from the ATO to DHS and DHS applying compliance risk rules, whatever they may be. But specifically, when a customer doesn't provide a response within the specified time, DHS makes the determination of appropriate administrative action based on the information provided by the ATO. This appears to be information drawn from DHS, which was being circulated within the ATO in January 2017. Is that right?
So again, my understanding from looking at that email is that this is likely to be a DHS document which they display on their website. I have no knowledge, but from my reading of it, it does not look like a document that had ATO involvement in its generation. I think I would agree that the view of the ATO was that we were sharing this information for compliance purposes for DHS. The last paragraph is, again, a representation of DHS's processes, not the ATO's processes.
That is the purpose to which the ATO information was being put, or the manner in which it was being used by DHS.
Yes, I would say that's the specific way. Like, it's from the ATO's perspective, I would say it was, in our understanding, it was being used for compliance purposes. The exact manner in how it was being used for compliance purposes was not, from my reading of the document at the time, was not in the knowledge of the Tax Office.
We've moved forward at this point to 6 January 2017, but you would agree that the exact use to which DHS was putting the data provided by the ATO was not within ATO's knowledge, as you say, for a variety of reasons, one of which because the ATO never asked DHS, what are you doing with it, in any specific sense?
Yes, so I would say that the ATO would needed to be satisfied it was used for the purposes of a social security law. Once we were advised it was being used for compliance purposes, which I think it was pretty clear it was, that would be the end. We would not be expecting to understand their exact compliance processes. Even
though, if their exact compliance purposes or the use to which they were putting it might not be lawful. That is, you wouldn't take a further step to satisfy yourself that what you were told by DHS accurately represented the true use of the information.
So Council, obviously if they assert to us it's being used for compliance purposes, and it is being used for compliance purposes.
It's the second point that I'm getting at. They assert to you it's being used for compliance purposes. How do you know? How does the ATO satisfy itself in the context of a bulk data release which would otherwise be involve the commission of offences on a large scale?
So Council, I'm not sure if you're suggesting that we should have done some sort of, it's not the role of the Tax Office to do some sort of audit, some sort of legal compliance audit of Services Australia.
No, but it is the role of the Tax Office to satisfy itself that the purpose for which it releases the data is the administration of social security law, correct?
But a purpose is for the purposes of a social security law, yes.
And apart from being told that it is by DHS, what I'm getting at is how does the ATO satisfy itself of that, or does it just take the word of DHS?
So I would say that fundamentally we would believe DHS.
Appreciating the risk that ATO might have where the fundamental secrecy provisions, which it takes very seriously, might in fact be breached on a wholesale level if in fact it wasn't to be used as it was said by DHS.
So again, putting aside the A purpose, the purpose type analysis, fundamentally we rely on the fact that DHS and other agencies use things the way that they say they're using them.
But they didn't
That
say
purpose.
how they were using this, did they? I mean, it seems to have come as a surprise to the ATO that income averaging was going on.
Yes, Commissioner, the precise way in which they were using the data was not known by the tax office.
Okay.
The fact that it was being used for compliance purposes was the basis on which we shared it. We did not ask for the specific ways in which they were administering their compliance program.
And you don't go the further step of making sure it's lawfully being used for compliance purposes?
No, we don't. We rely on the fact that other agencies are operating in a lawful basis, and indeed that under the framework they should be advising us if they are using it if they are not doing things on a lawful basis. So, and that is under the header agreement in relation to the information sharing between the ATO and DHS. There are various requirements on both agencies.
Commissioner, could I just raise an issue in relation to the passage of this evidence and the question that you have asked? It has at times passed between focusing on the period under investigation and present day. There's a mix of what was, what is, what was, what is. I can take it up in re-examination, but if I just flag...
Yeah, I'm simply asking about the position at the time that the Robodebt scheme was commenced. We say that's 1st of July 2016.
Thank you for that clarification, Commissioner.
In for the moment. You understood that, Mr Hirschhorn?
Yes, Commissioner, and I might make reference to the head agreement and the service agreement which sits underneath that agreement which has been provided.
Thank you.
If we turn then to Exhibit 262, ATO.001.635.7634, the topic is a Centrelink briefing document, and it's 12 January 2017. If we go to the page ending 7639, we see that the trail commences on 21 December 2016 and then continues into January. The reference on the second half of the page, 7639, is a reference to a Crikey article which had been mentioned, and we note that there was significant media interest identified in earlier emails, and it was an article entitled How to Dispute a Centrelink Debt. It continues over the following page. That is, it's set out in full. It's clear to say, isn't it, that the ATO was keeping abreast of media reporting in the December-January period in respect of what was the Robodebt scheme?
Yes, from
And
the email correspondence, you can see that we were very interested.
Yes, and it was therefore aware of the range of criticisms which were raised in the media about the scheme.
Yes, again, from the emails, it's clear that relevant officers were closely monitoring the press.
Thank you. We go then to the page 7637, This is an email in the trail on 3 January 2017. And thank you very much. The sequence of emails, of course, includes the Crikey article, but we get to 3 January 2017 where there's a reference to it. And the information which had been developed in the meantime was from Michael Brown, and it's excerpted in the paragraph here. He says that he'd been dealing with DHS Centrelink issues in relation to this for the past month or so. IGT queries. What's IGT?
So the IGT was then the Inspector General of Taxation, who is a scrutiny body of the Tax Office. Since then, that has been amalgamated with the Taxation Ombudsman. So it's now the Inspector General of Taxation and Taxation Ombudsman.
Right.
But that is, at the time, was a scrutineer of the Taxation Office.
So there had been an external body or office or person who had asked some questions of the ATO.
Yeah, so my reading of that is that we have certainly received, it says that we've received a query, whether that's an own motion query from the press or whether that's as a result of individuals contacting the IGT, I can't tell, but that is what that is suggesting.
And again, what is identified here are the two fundamental differences to the way that DHS conducts its compliance program from 1 July 2016, noting that the forerunner was under the Data Matching Act and had been since its inception, and then the DHS had chosen for administrative convenience to step outside the auspices of the Act and go under the banner of the Office of the Australian Information Commissioner's guidelines. With the consequence that the ATO was no longer able to exchange TFNs as one of the identifiers, but as I read it, and I'll ask you for confirmation, otherwise the usual identity matching process occurs.
Yes, so by that, my understanding of that is that we've, at the relevant time, we will have been sharing, albeit we've been sharing information with Services Australia under DMP, we will have been sharing information with other agencies not under the DMP, and so our usual information sharing will have been without using TFNs under a general exception to the taxpayer secrecy rules.
I understand. There's a note that the ATO now understands that DHS has adopted a new automated online platform for the compliance program, and that according to the media reports, a number of systemic issues were raised, and 3 are noted there. DHS wasn't undertaking any additional identity matching processes when the data was returned to them, and you've dealt with how that led to mismatches of identities and attributing letters to the wrong people. The second was that DHS are averaging income across entire financial years, where people may have only worked for part of a year and or their hours or salary may have varied within pay periods. What's the significance of that as a systemic issue from the ATO's perspective?
So, again, from my understanding of the various emails, it's this is at this stage a concern raised in the press, and the relevant officer is concerned. So my reading of the emails is the relevant officer is concerned that this may not be accurate, where people earn on a volatile basis.
Can I draw your state of mind from a matter of history to the present day? Was the information that was provided by the ATO, to your current knowledge, fit for the purpose for which it was being used by DHS?
So it is, the data we were providing was annual data. I think it was data that was fit for the purpose of identifying the potential for discrepancies. My personal opinion, so because this is about somebody, can I say, this is about a different act, my personal opinion is that an assumption that income was for in a sense, assessment purposes, simply averaging that income would be given accurate reflex. It's not the data is not the data is not fit for purpose for a definitive allocation to fortnights.
That's right. And thereby the calculation of debts as a result of that averaging process.
That is correct.
And that appears to be what that particular sentence is directed to, as an understanding of the issues that had been raised in the media at the time.
Yes, that is my understanding of the email.
The final paragraph of the page, we met with representatives, identifies a meeting between the ATO on 14 December 2016 to discuss some of those issues, and there were verbal assurances provided that they would implement additional process steps to address many of them. There was a letter written on the 22nd of December seeking written assurance about measures to reduce the ATO exposure, but no response had been received, at least by 3 January 2017.
Yes, that's my reading of that paragraph.
Can we go over to the next page, ending 7636, sorry, the page before it. Monday, 9 January at the top of the page. I just want to ask you about some language that's used here. It's from Ordine Graham to Tyson Fawcett. Again, it's part of the trail. The note is that the subject seems to be gathering a little pace. Greg will be back tomorrow, who I understand is Greg Williams. What position did he hold?
So Greg Williams at this stage was Deputy Commissioner in charge of Smarter Data, so a very senior officer.
Yes. And the phrase used is, just wanted to check Ree Allison's question, and if you consider it would be, inverted commas, need to know for Greg or Neil Ollison to be aware. What's the concept of need to know?
So ordinarily, the concept of need to know within the office is that, so in terms of taxpayer confidential data, it cannot, we've spoken about it being shared with other agencies, it cannot be shared freely within the agency unless there is a need to know the information. So that is the context in which need to know is ordinarily used. My interpretation of this email, that's a strange use of the phrase need to know in this email.
Yes, it doesn't seem...
My interpretation of this email is more that with, because Ordine is, I think, Greg Williams, either EA or PA, so in his office.
Yes.
My impression is whether they need to know today or can wait for Greg to get back. But I'm only interpreting. And if I could maybe comment, Alison Lendon is Deputy Commissioner, I think at that time in charge of individuals, so a peer of Greg's, and Neil Olson is my predecessor as Second Commissioner in charge of Client Engagement Group. So it is now escalated to a very senior level.
Yes. The email continues, if we go through the pages back to the front page, where it seems that Mr. Williams had been told and asked some questions about it, and a briefing paper had been worked up in a response to those questions to get clarity within the ATO about what was happening.
Yes, in my understanding, this briefing paper was prepared ultimately for the purpose of briefing both Neil Olson and the Commissioner.
We'll turn then to the briefing paper. If I can find my note of it. Exhibit 263, ATO.001.635.7642. This is the briefing paper that that email refers to?
Yes, that is my understanding.
All right. And you say it was prepared for briefing to Mr. Ollison and the Commissioner?
So my understanding is, again, from reading the information, is that at about that time it was, whether it was prepared initially for that purpose, but ultimately it was provided to Mr. Olson and the Commissioner.
And do you know when it was provided to each of those persons?
Yes, so my understanding from the correspondence is that it was sent to Neil Olson's office, and then Neil Olson had a meeting with the Commissioner concerning it. I'm not, can I say off the top of my head, I'm not sure from the email correspondence if there's an email to the Commissioner of the brief.
Certainly. But it would have been about this time in January 2017.
Yes, so my recollection, and indeed I don't have the paper files in front of me, was that it was on the 13th of January that it was provided, or that meeting was held between Neil Olson, the Commissioner, in relation to this briefing paper.
There are a number of topics. If the first, under the heading background, just details the increased media interest and a brief overview of the DHS debt recovery program, which utilises ATO data. It says this is not a new program and has been conducted approximately for 25 years. Do you know on which basis it was asserted that it wasn't a new program?
Yes, so my interpretation of that paragraph is that it was referring to the fact that ATO data of this nature, the same data fields, had been used by DHS, for, can I say 25 years, it says here, at least, I've no reason to doubt that. It's certainly been since the start of the DMP, has been used for compliance processes by DHS.
Right. There's then follows a subheading that what has changed since July 2016. The first dot point identifies the acute awareness that the Data Matching Act was not being relied on, and that the TFNs weren't therefore used. And the third dot point from the bottom is that DHS have now chosen to undertake the program under the OAIC's guidelines. That's the voluntary guideline. Pausing there, of course, because it's a voluntary guideline, also the ATO must have chosen to undertake the provision of the data under those guidelines.
Yes, indeed, that it's an optional, well, so not necessarily under the guidelines, so that the ATO has reached the view that it is capable of sharing it for the purposes of a social security law.
Yes, but it's not required to.
It's not required to. It is now a choice to provide the information.
That's right, yes. The next two dot points, if they could be called out, please. And again, this is under the heading of what has changed. This reflects the ATO knowledge that DHS has largely automated the discrepancy matching program and the correspondence issuing platform that involves some human oversight prior to correspondence issuing. That's a reflection of the human involvement pre the Robodebt period, as I understand it.
Yes, so that would be my read of that paragraph.
And the last paragraph is what follows from the automation of the program, that is, letters being issued of approximately 20,000 per year, but the new system generating the same number of correspondence per week.
Yes, so that's obviously the understanding of the author at the time. I'm not sure if that's exactly correct, but obviously there was a significant expansion.
Yes. If we go over to the issues identified by the ATO on the following page, 7643, 3 are identified. The false positive identity matches, you've already addressed those, in part flowing from the lack of precision on occasions brought about by the inability to identify a tax file number between the two agencies. The second relates to the income averaging, which was raised in the earlier email, and that this income averaging was an issue because of what you identified earlier, and it seems what was identified here, is that it's unlikely to give an accurate indication of fortnightly income for compliance purposes.
Yes, it can only be, in a sense, averaging it can only be indicative, not determinative of what somebody has earned in a fortnight.
Yes. Have you identified at this point whether the ATO sought more than just the verbal assurance it had received from DHS about the administration of social security law being in accordance with the law, given that averaging question?
So from my review of the documents, at this stage in January, there has been no seeking of legal advice by the ATO directly or a request from DHS. And I'm no doubt you will be moving to this meeting at some stage, that the escalation point appears to be a meeting in February with DHS.
Just before we come to February, and I am going to come to that meeting, in the course of reviewing your evidence and preparing for it, an email was identified dated Wednesday, 25 January 2017, which referred to something you have already just confirmed, and that is the email between Mr Brown and Mr Fawcett that confirmed that the ATO was now operating outside the Data Matching Act and that there is no longer the compulsion on the Commissioner to provide the data to DHS or Centrelink. I won't bring up the document for various purposes, but again, that was the state of knowledge of the ATO.
Yes, certainly the ATO was working on the basis that it was not providing it under the DMP, but was providing it under the general exception to secrecy.
In circumstances where it had no obligation to do so, but chose to do so.
Indeed.
We'll turn now to the meeting in February. Exhibit 272, ATO.001.572.3540.
Is there an exhibit number for that? Do you know?
Sorry?
Exhibit number?
272 on my note. If we can go to the last page to keep things in order, ending 3543. The email is self-explanatory. On 31 January, a number of people were invited to attend a meeting on 7 February 2017 to assist both, that is a meeting between DHS and the ATO to assist the understanding of the online compliance intervention program.
Yes.
And Deputy Secretary Melissa Golightly, a person from DHS, was to provide a debriefing around the current situation and any further DHS action planned which may have implications for the ATO.
Yes.
If we go then to page ending 3541, this is an email 7 February 2017 from Michael Ingersoll to Alison Lendon, copying Mr Williams, who you have identified, and it's following that particular meeting. Firstly, who is Mr Ingersoll?
So Mr Ingersoll, as I said, various roles over time. I think from, I would suspect at this time he is the Assistant Commissioner, an Assistant Commissioner in Smarter Data, possibly an Assistant Commissioner in individuals, but he is an SES Band 1 at this point. So he has sent that email to Alison Lendon, who's the Deputy Commissioner of Individuals. Greg Williams copied the Deputy Commissioner of Smarter Data and to all of the SES in individuals.
And this was the summary of what Ms Golightly told the ATO in the course of that meeting. I think it was a telephone meeting from your reading of the records.
Yes, so there's, I think several notes of that meeting.
Yes, provided by different parties to it.
Yes.
This is Mr Ingersoll's note. The description that's called out on the screen is that Ms Golightly informed the ATO of various things. That firstly, they hadn't changed the way that DHS undertook data matching. You've identified the changes from the ATO perspective, but this was from the DHS perspective. It was said...
Council, I'd say that in a sense it's a different legislative mechanism, but pretty much the same data from the ATO perspective.
Yes. The second dot point was how DHS used the information to determine welfare payments had not changed either. That's the record made by Mr Ingersoll of what was said at the time.
Yes.
Did that appear to be inconsistent from the documents you've noted with the earlier reference to the averaging concept which was identified as an issue under this program by the ATO?
So my understanding from this email was that what they were doing at the time of Robodebt was, all the notes of this meeting say, and assuming that what we were told was correct in those meetings, was that the customer had been given an opportunity, was told there is a discrepancy based on the use of the ATO data. It appears there may be a discrepancy. Please provide information as to your actual earning pattern throughout the year. But if the client did not respond, then an averaging approach was applied. From my review of the documents, there is nothing, we have no knowledge of what they actually did in the pre-Robodebt period. So it is possible, from my reading of the documents, there's nothing to suggest that they didn't do that before Robodebt. It's just that it became a bigger issue because they were doing it in relation to more people.
And that was the nature, as we can see here, of the information which was conveyed to the ATO by a Deputy Secretary within DHS.
Yes.
And again, I understand what you are saying is that your review of the records indicates that the ATO assumed that what they were being told was accurate.
Indeed, and there's nothing that I've seen from the review of the documents to say whether that may well be accurate. It may well be that they were doing that beforehand, but certainly from the notes of that meeting, all officers assumed that what they were told was accurate.
We go over to the page. The notes are completed there. There is a reference to error rates, businesses, the government being confident of the system. Michael Ingersoll's question is referring to a complaint. Are you ready for Senate questions re the provision of ATO data not under the specific legislation? And the answer attributed to Ms Golightly is yes, we've had similar complaints and are ready for such a question. There doesn't seem to be any fleshing out of that issue according to the balance of the notes.
No. No, my suspicion from reading that is that it relates to maybe the mother-daughter type problem. But it's only a suspicion from reading that paragraph.
The reference to ATO data not under the specific legislation suggests a reflection of the understanding that the Data Matching Act wasn't being used in the process.
That's right. So my reasoning there being that this is those sorts of issues did not arise when there was a TFN matching as well as matching on other attributes.
Mr Gregory, will you be some time?
Yes, is that a convenient time?
Certainly.
Commissioner, before you rise,
Yes.
we don't have access to yesterday's transcript. Could I make an application for access to the draft transcript?
Yes, I'm sure somebody can arrange that for you. I don't know if I have it myself, but if I have it, you're welcome to it. Just while somebody else gets, give it to
Thank you, Commissioner.
Ms Hogan-Doran. Okay, we'll come back at 10:02, I think. Thank you.
All rise. The Royal Commission stands adjourned
Till 10:02.
till 10:02. Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Thank you. Without referring to the document, Mr Hirschhorn, I'll walk you through another feature of the ATO knowledge at a particular point in time. And can I confirm that on 9 March 2017, officers within the ATO understood that when the Department of Human Services conducted debt programs or debt recovery programs under the Data Matching Act, that they were required to report to Parliament on the effectiveness of the program, and that was done periodically between 1990 and 2010, and then included in the DHS annual report between 2011 and 2016.
So my understanding from is only from the emails that I've reviewed, and that there were some reporting obligations. Yes.
Yes. You may take it from me that I've read from an email circulated within the ATO, an exhibit ending .1073, which records effectively what I've read out to you.
Yes.
That is that the ATO understood that one of the obligations imposed by DHS under the Act was its reporting obligation to Parliament and then through its annual reports.
Yes, so that's my understanding from reviewing the emails.
Yes, thank you. And can I turn then to I think it might be Exhibit 283, but I'm not confident. It ends in, it's ATO.001.644.8921.
That looks right.
If that could be brought up on the screen, please. And if we could go to the second page. Again, for temporal context, Mr Hirschhorn, we've moved to 7 July 2017. And the email is from Mr Fawcett to Ms McRae. That is Mr Fawcett in the ATO to Ms McRae at Human Resources. You see that?
Yes.
Thank you for the catch-up following the DHS/ATO operations meeting today. Now, the DHS-ATO operational meeting today, or the operational meeting, was not the data forum or the consultative forum meetings which we identified in the table in your evidence yesterday. This is a different type of meeting.
Yeah, on its face it is.
Yes. You might take it from me, although I'm happy for you to check your statement if you wish, that on the dates that you deal with in your statement at paragraph 6.3 and following, there's no reference to a meeting on 7 July 2017 in respect of either of those fora.
Yes,
That's correct. Yes, all right, I understood that correctly. Have you been able to identify minutes from the operational meeting which is referred to there?
Unless look, can I say I'm not aware from the top of my head. If they have not been provided, then we have been unable to locate them.
All right. I can't assure you that they haven't been provided because we're in the hundreds of thousands of documents. I can assure you that I haven't found them. But in any event, you haven't identified them to your immediate recollection.
To my immediate recollection, and if they had been identified and considered relevant, they would have been referred to in my statement.
Okay. The topic of the email uses some strong language, which I'll come to, but the data matching meeting was scheduled as soon as Ben returns. I understand that to be Ben Lumley at DHS. The second point is that the ATO is seeking an assurance on the use of its exchange data provided to DHS on how it is being used with any future bulk compliance approaches, brackets, lessons well documented. Without the minutes, it's a little hard to understand what specific assurance is being sought, but we do know that it's in respect of the DHS use of the data.
Yes, and can I say I have no further insight into that,
Yes.
into what is specifically being referred to.
Well, beyond what's referred to there. Mr. Fawcett said, I'm seeking an urgent discussion, brackets, next week at the latest on this. Otherwise, I ask that you cease and desist the usage of the data until we have your assurance around the data use. Now, as you read that document, is it your understanding that what Mr. Fawcett foreshadowed, subject to an urgent discussion, in which there was an assurance around the data use, that the ATO was asking for the data it provided to DHS for its Robodebt scheme to not be relied on?
That is my reading from the face of that email. I have no knowledge, and I suspect it is no coincidence that the next meeting of the Data Management Forum was on the 20th of July.
Yes. But that's a couple of weeks later. In July 2017, the ATO position was of a sufficiently high level of concern to request the DHS stop sending the letters relying on ATO data in the absence of a specific assurance around data use, which is not identified in this email.
Yes, I would say, yes, an officer of the ATO
Yes.
is obviously quite concerned around the use of the data.
Yes. It would make sense, wouldn't it, that the level of concern whereby an officer of the ATO asks DHS to cease and desist in its use of ATO data for the Robodebt scheme must have derived from the potential exposure to the unauthorised disclosure of data for a particular purpose, which was not in fact the administration of social security law according to law.
I'm not sure if I can agree with that, Council. Certainly there is a concern that the data is being not used in a way that that officer is comfortable with.
And the only way he could not be comfortable with the use of the data was that it was understood to be provided by the ATO for the purpose of the administration of the social security law, thereby an exception to the secrecy provision, but was not in fact being applied to that purpose according to law.
Again, Council, I would not agree with that proposition. He may well be concerned around not only the legality of data use, but also the ethics of data use.
And the concern was sufficient to issue a forewarning of a cease and desist order to DHS in its continuation of the Robodebt scheme.
Yes, well, certainly it's the use of a strong phrase, whether correctly or not, but the use of a strong phrase.
It is the strongest phrase we have seen from all of the material gathered by the ATO to date, correct?
Yes.
And it was potentially foreshadowing that the ATO was not comfortable with the program continuing, subject to the specific assurance that it sought.
Yes, certainly that officer is concerned with the continued operation of the scheme as is.
And the use to which the data was being put, I suggest, is directly relevant to the purpose for which it was provided by the ATO under the exception.
I'm not sure if this could be referring to the legal use of the data. It could also be referring to, and whether it was legally provided by us. It could also be referred to an administrative misuse or a data ethical misuse of the data, not simply a beyond legal purpose misuse.
If we go then to the first page of the document, we can see that Ms McRae responds within a couple of hours at the bottom of the page and indicates that a data management forum will take place on 20 July 2017. But the assurance provided in the short term was that we, that is the DHS, would continue to work through the ATO DHS optimisation program, consider the need to facilitate a face-to-face working group meeting to go through some of the technical aspects, and that in the second paragraph it was identified that there are currently a range of measures the government has asked us to deliver which rely on data matching capabilities of our organisations, and this work needs to continue. When you read that, did you understand that that was a pushback against the proposal by ATO and the prospect of the ATO saying you cannot use our data anymore by reliance upon a government imperative and DHS adopting the position that because the government had said the work had to be done, it would continue?
Yes, again, reading the email, certainly it is pushback against the previous email. That is a reason, it's a reason that has been given for the pushback and an attempt to escalate to the SES level.
That is, there was the leveraging of some political weight against the question of lawfulness.
Again, there's the mention of political weight. I'm not sure from the face of these emails, and again, not having been involved, not knowing what was in the mind of the officer, I'm not sure if it's versus a legality or whether it may well be against an ethical use.
I understand.
Or merely a view as to administrative misuse.
I understand, and I don't mean to presume something that I can see on the full face of the document and you can't on the passage which is excerpted, but I'll come to the response, of course, from Mr Fawcett shortly. But if the second last paragraph refers to PAYG and NEIDM protocols, that's the non-employment income data matching protocols, on our website, and working with the OAIC to review and update the remaining data matching protocols undertaken by the Customer Compliance Division. Now that's a reference to protocols which are envisaged by the voluntary data guideline to which repeated reference has been made, under which the bulk data was provided.
That would be my understanding.
Yes, all right. But if I come back to a concept expressed in the cease and desist phrase, is it the case that the reference to the foreshadowed possibility of a request to cease and desist reflected the fact that the ATO was not of its own volition able to stop the process because the data had already been provided?
Yeah, so my read of that email is, well, the information has been provided.
Yes.
Services Australia is in possession of that data. Any sort of leverage of holding back data is not, there is no leverage of holding back data because the data has been provided.
Yes.
Is my read. And then the use of a pseudo-legal phrase by the officer is expressing his concern.
Yes. What it reflects, I suggest, is that data was being provided in large volumes from 1 July 2016 without the ATO getting any clarity of understanding about the use to which the data was actually being put by DHS. Apart from their broad assertion, we're using it for compliance activity under the Social Security law.
Yes, so the ATO, from my reading of the documents, the ATO understood that it was being used for compliance purposes, that was, effectively in a risk assessment phase, and then ultimately and subsequently, but the ATO was not aware of the exact the exact ways in which the data was being used.
That is, whether it was in fact being used for the administration of social security law according to law.
Indeed, if every use of it was in accordance with law, and again, just referring back, it was provided under the auspices of a head agreement and a subsidiary agreement, which had various requirements on both parties in relation to advising if there were concerns around the use of the data.
Right. We can conveniently put those agreements to one side for the purpose of the lawful basis on which the ATO provided the data, because that's confined to the exception to the secrecy provision, which we've identified repeatedly.
Yes.
And the head agreements merely relate to process and a cooperative working arrangement, which presupposes a legal basis or a lawful basis on which the data may be provided.
Yes. Yes.
If we go then to...
But maybe, Council, to clarify the point that I've
Yes.
been trying to make, perhaps unsuccessfully, is the information could well be provided completely lawfully under that exception, because it is being used for a purpose under the Social Security, a lawful purpose under Social Security law, and then subsequently also be used for an unlawful purpose.
Undoubtedly.
The provision would still be permitted.
Undoubtedly,
original provision.
because the ATO couldn't control ultimately the end use of the data provided it was provided lawfully.
Indeed, and the head agreement and the subsidiary agreements are agreements between the organisations to try to control the use of the data after it has been provided.
But I think the distinction that we had identified earlier, I asked you to clarify earlier, was the difference between the assumed lawful use and whether the ATO had taken any steps to satisfy itself beyond the representations that were being made without the provision of legal advice or the sharing of legal advice by DHS or DSS.
Yes, so the ATO had not taken any specific steps to assure itself that every use of the information was lawful under Social Security law, apart from its generic or its structural approach to that, which was to sign a head of agreement which put obligations on both parties.
But that head of agreement pre-existed this particular program?
Yes, but applied to this program.
Certainly, but it wasn't a step taken by the ATO in respect of the change brought about from 1 July 2016 under which the data was provided.
No, it was a structural document between the parties.
Yes. If we go back then to the first page and the response from Mr Fawcett to Ms McRae, he acknowledges the calendar entry for 20 July 2017. He's responding early on the following Monday morning. The passage makes it clear that the ATO continues to support the DHS initiatives, but does so ensuring the data is shared is done so in accordance to the law. And that's why I was suggesting to you that the question raised in the cease and desist phrase and the concern about its use and the pushback leveraging political weight against a lawful question was put to you, but I appreciate you didn't have the first part of, or the final part of the sequence available to you. But do you accept now that that really is the tone of what is happening here between the ATO and DHS?
I'd say between that particular officer, he is making representation that he has a concern that something is not in accordance with the law. I don't know which law he might be referring to.
Yes.
Or indeed whether he is actually referring to a legal question. Mr Fawcett is not a lawyer, or whether he may well be referring to a different sort of problem, but merely referring to it as a legal question. I just don't know what was in the mind of Mr Fawcett.
No, we may have to hear from him. The reference to the PAYG and NEIDM protocols under the in accordance with the Office of the Australian Information Commissioner guidelines are dealt with in the guideline on data matching in the Australian Government Administration. That's the voluntary guideline under which the ATO shared its data with DHS for the Robodebt scheme.
Well, again, we provided under the exception to the secrecy rules, and then the guidelines were adopted in relation to the data sharing.
Yes. All right. It is Exhibit 505. I don't immediately have a number available to me.
I've got a note that it's 9999 .0001.0003, if that's any help. ATO at the beginning.
I'm told that's right. And if we could call out the heading and the date underneath it. This is the document issued by the Office of the Australian Information Commissioner, which is the guideline to which reference has been made.
Yes, that's my understanding. Yes.
Dated 18 June 2014 and in force, to your understanding, at the time the Robodebt scheme was running in 2016.
Yes.
Some key terms are identified, obviously, under the heading key terms in 4 dot points on the first page. I ask that they be called out. The first is the concept of administrative action, which, would you agree with me, includes the Robodebt scheme?
Yes, on its face, it would include the Robodebt scheme.
Because it incorporates action taken in response to a match obtained through a data matching program that materially affects an individual or class of individuals, and the various effects are inclusively defined in the 3 dot points, including action which might be directly detrimental to an individual, such as reducing a benefit or imposing a penalty.
Yes.
Squarely within the Robodebt scheme, and there are some others which apply as well.
Yes.
If we go to page 2 of the document, under the heading Background, the purpose of the guideline and who should use the guideline. Thank you. What the guideline makes clear, you would agree with me, Mr Hirschhorn, is that its aim is to assist in this particular context in the Robodebt scheme, the ATO and DHS administer data matching in a way which complies with the Australian privacy principles, which are, of course, established by legislation.
Yes.
And it's an object of good practice. It sets out what is good practice or best practice for the agencies.
Yes, I think as best practice was understood in 2014.
Yes. But, as you've identified, it certainly applied in 2016 when the scheme was underway.
Yes.
It might be updated now, but it's clear from point 2 under the heading who should use the guidelines. The guidelines should have been used by both the ATO and DHS, correct?
Well, I would say as a matter of technicality, our view would be that Services Australia was the data matching agency.
Yes.
And so they were the ones determining whether administrative action was warranted. But fundamentally, I would agree as an agency sharing information to somebody who is doing data matching, we should be having regard to the guidelines.
Absolutely. And just to develop that point, on the concept of sharing, you've accepted, of course, what is contained in the ATO material back at the relevant time, that because of the move out from under the Act, there was no obligation on the ATO to share the information. It was effectively partnering with DHS in respect of the compliance activity by the sharing of the information.
I'm not sure if I would use the word partnering, but I would use the word that it is certainly assisting Services Australia achieve its goals.
Perhaps I can put it in the negative. Without the cooperation of the ATO to provide the source information, the compliance program couldn't be carried out by DHS.
It would not have been able to be expanded in the way it was because it would have had to rely on the information provided under DMP.
That's right. Limited to the state of affairs which existed pre the Robodebt scheme of 20,000 interventions or so per year rather than 20,000 a week.
Yes, it would. Well, Services Australia may well have been able to expand its program, but it would not have been able to do, I think we discussed yesterday, go back as far, for example. I don't know how much it could have ramped up under the DMP.
And when you say DMP, you mean the Act?
Yes, the Act.
Thank you.
So putting to one side the difference between assisting and partnering with, you appreciate that the ATO cooperation is necessary for Robodebt to occur.
Yes.
And the status of the guideline, of course, represents a document that is voluntarily adopted by agencies involved in the sharing of data, but of course it represents best practice.
So that is my understanding, is that it was both voluntary and that it represented at least good practice. Of course, we also had an effectively additional bipartisan or bilateral guidelines, which were our agreements directly with Services Australia.
Of course. You're referring there to the heads of agreement and the like, which are contained in your statement.
Yes, which would include additional responsibilities over and above the guidelines, is my understanding.
Certainly, though, this guideline, as you've said, applied to the data provided by the ATO to DHS under the Robodebt scheme.
Yes, so my understanding understanding is that Services Australia indicated to the Tax Office that they would be seeking to apply the guidelines.
And when did they indicate that?
So that is right from the start, Council, when some of the earliest correspondence you referred me to yesterday referred to the fact that Services Australia acknowledged that they would be seeking to apply the guidelines.
The email of 10 July 2017, to which we just referred, the cease and desist sequence, suggests that it was only recently that protocols had been published under this guideline on the DHS website. From your review of the data...
That's my read from the face of the email.
That is, the scheme was underway for approximately a year before DHS published protocols under this guideline issued by the Office of the Australian Information Commissioner.
So that's my read of the email. I have no knowledge.
Yes. Have you identified anywhere in the documents that the ATO took steps to ensure that as the agency making administrative decisions based upon the ATO data, that it followed through on its assurance that it would comply with the guideline and publish protocols at the outset?
I have not identified that, no.
Again, this is an example, I suggest, of the ATO accepting an assurance from DHS but not following up on it to test whether things were in fact occurring in the way that it was represented to the ATO.
Yes, so I have not seen any evidence of us doing that follow-up.
It would be an important thing to follow up, wouldn't it, from the ATO's perspective, when it's about to share bulk lots of data outside the Act?
Again, I would say it would obviously be better practice to have followed that up. It is, but it goes, my understanding is it goes more to the obligations of DHS than the ATO. It would not be a matter of legal conformance by the ATO.
As we go through the guideline, it will become clear that had DHS done what it said it would do to the ATO, according to your evidence, and published protocols early, the particular use to which the ATO data was being put would have been identified with sufficient clarity for the ATO to make an assessment on whether the disclosure of the data was for the purpose of the administration of the social security. Would you agree with that effect of the protocol?
Look, I just don't know.
You don't know. Okay. If we go to paragraph 2.3, participating in a data matching program. Yes, I asked that paragraph 2.3 be called out. Thank you very much. The reference in paragraph 2.3 is that the Information Commissioner encourages agencies that are considering whether to participate in a data matching program, particularly a new or large project, to carry out a privacy impact assessment on the project. And the Commission has obviously published a guide to a privacy impact assessment. See that?
I see that, yes.
In short terms, the data matching program, which the ATO voluntarily entered into with DHS under this guide, was one which would fit within a new or large project of data matching, correct?
Yes, in one sense it is a new project. In another sense it is a continuation from the perspective of the Tax Office of sharing broadly the same data, but on one view I could see that it would be a new project.
It would also be a large project. It's said to run for a number of years and involve high volumes of taxpayer information released at least twice a year for a number of years for this particular compliance program.
Yes, again, if you view this not merely as a continuation or expansion of an existing project, it is certainly affecting many individuals.
Well, it fits the description of a large project, doesn't it, when you go from 20,000 compliance interventions a year to 20,000 a week?
It is certainly much larger. The question is about, to me, the question, or maybe even the blind spot at the time, was whether it was, from the ATO's perspective, whether we were considering whether to participate because we may have viewed ourselves as already participating. That this is merely a continuation.
But it wasn't, this protocol didn't apply to what the ATO was doing under the Act, did it? Because the information was given under obligation under the Act, and this is a voluntary program, plainly a change of program from the ATO where they decide that they will agree to a proposal to voluntarily provide information under this guideline. It has to be a new program, doesn't it?
That is, yes, that it is. It can easily be characterised as a new program.
Well, it couldn't be characterised as anything else. This is a guideline which applied to the provision of data by the ATO to DHS.
This is the guidelines. Well, DHS agreed as part of the change in the program to move to an approach where the guidelines, it was going to adopt the guidelines.
Given that the guideline was going to be adopted, an agency that was considering whether to participate under the guideline had to consider whether to carry out a privacy impact assessment. Did the ATO do that?
From my understanding, we did not.
Why not?
Well, I was not involved personally, Council, but my understanding, well, my speculation, it can only be speculation, would be that we view this as a continuation of providing the same data that we had always provided.
That was obviously a flawed assumption, wasn't it, if that was the assumption taken?
Well, from a functional sense, it is the same data that was being provided, that had always been provided.
What you've just agreed with me, though, is that this guideline applied to data provided under the Robodebt scheme, and the guideline encouraged the ATO in considering whether it would participate in the voluntary provision of data to carry out a privacy impact assessment.
Yes, and Council, you asked me why there's no evidence that was considered, and was saying that because I think in the minds of the relevant officers at the time, they did not take a legalistic approach to this. They viewed this as providing the same data that had always been provided.
But this is not a legalistic document. This is a practice guide. Why wouldn't there be regard to it if it applied to the provision of data on a voluntary basis?
I have no further answer.
It's an obvious shortcoming in the ATO's response to the voluntary provision of information that it didn't have regard to a privacy impact assessment.
Sorry, is there
You'd have to agree with me about that. That the ATO, when it does not have regard to a practice guide issued by the Information Commissioner in considering whether it will voluntarily provide bulk data, doesn't follow what is recommended by the guide. It's an obvious shortcoming in the ATO approach.
I would agree that it's better practice. We should have considered whether we had to carry out we should have carried out a privacy impact assessment.
And the Commission has published, as it says, a privacy impact assessment guide. But if we don't go there yet and we look at a program protocol, before, under guideline 3, if we can go down the page, guideline 3, paragraph 3.1 and 3.2 could be called out. Now, this is before commencing the data matching program, so pre-1 July 2016. The primary user agency, in this case DHS, you would agree with me, should prepare a program.
Sorry, Councillor, I'm not sure what the definition of primary... Can I say I've not overly familiar with this document in terms of its content. Can we go back to the definition of primary user? If you're asking,
Certainly.
I'm relying on your assertion that they are the primary user agency.
It's the agency that makes the most use of the results of a data matching program.
And I would agree that that is DHS.
Yes. It followed on, I thought, from your understanding that the bulk of the obligation in the development of the protocol was borne by DHS.
Yes, I just don't have that definition in front of me, of course.
Certainly, yes.
Copy. I have the extracts.
And I should say, at any time, if you do want to double check something, please make sure that you're clear about it. The primary user agency should do a number of things: prepare a program protocol in accordance with an appendix, provide it to the Office of Information Commissioner, make it publicly available. But 3.2 says that each entity involved in the data matching program should ensure that its participation complies with the program protocol, and again, that's a reference to the ATO as well.
Yes.
We go down then to paragraph 3.3.
Would you be more comfortable with a hard copy of it? Because I have a spare if you want it, Mr.
Commissioner, it would be very useful if I could have a hard copy.
Thank you, Commissioner.
Thank you.
It's not page numbered, but I'll continue to refer to paragraph numbers. But the purpose, as we can see pulled out on the screen, is to inform the public about the existence and nature of the data matching program. It's a transparency process. You would agree? It's the purpose of the protocol.
Yes.
And paragraph 3.4 at the bottom of the page and over the page identifies what the protocol should contain, and if paragraph 3.4 could be pulled out. It starts in a broader sense and becomes more specific. Roman 3 identifies the matching agency and source entities. That would identify if the protocol existed, when it should have, both DHS and ATO. Roman numeral 4, a description of the data to be provided and the methods used to ensure it is of sufficient quality for use in the program. If I pause there, you earlier indicated that the information provided by the ATO was really not fit for purpose because of the means of averaging.
So I would say it was fit, well, can I say it was not fit for that purpose? I would say it was fit for some purposes, for example, detecting those who may have declared no income throughout
Yes.
the year. So it was not, maybe not fit for every purpose, but fit for at least that purpose.
Roman numeral 6, what action, administrative or otherwise, may be taken as a result of the program. At that point, the question of the data not being fit for purpose as a result of administrative action based solely on averaging would have been identified if the protocol existed.
Can I say again, reading this document and I say not being aware of a protocol, the action that might be taken might be that they might simply be the raising of debts. It may not talk about the exact mechanism of how those debts would be determined.
But we know, in fact, the data used by the ATO was averaged in order to raise debts as a matter of history.
Well, what we know, so again, from my understanding of the emails in February 17, being the best knowledge that the ATO had in February 17 of the use of the data, was that it was being used to raise matters for consideration to individuals. Then if the individuals failed to produce information, to then use it on an average basis to raise debts, is my understanding of what Ms. Deputy Secretary Golightly said.
And that was the best information available, as you say, to the ATO because it didn't take any steps to clarify what in fact the data was being used for in terms of legal advice or getting to the detail of the purpose to which it was applied.
The ATO, to the best of my knowledge, the ATO did not get detailed analysis of every step taken by DHS Services Australia.
And it would have been informed about the true nature of the use of the ATO data had this protocol been agreed between ATO and DHS back at the start.
Again, Council, it depends what the information to complete this protocol would have been completed by Services Australia. I'd just simply be speculating as to what they put in that protocol.
Well, you would hope it would be accurate information given the need to make the public aware about what was actually happening, but the ATO certainly had a role in the completion of the protocol, as we've already identified.
Yes, so the ATO has a role in the completion of the protocol, but the protocol, as I understand it, is to be initiated by the primary user.
Primary user, yes, DHS.
Yes.
Yes. Subparagraph B deals with an explanation of the reasons for deciding to conduct the program. Roman numeral 1 identifies the program's relationship to the agency's lawful functions and activities. 2, the legal authority for the uses and disclosures of personal information involved in the program. Alternative measures, information about pilot testing and statements of costs and benefits. And of course, none of that was done by DHS, and the ATO didn't require it to be done for its own purposes before it started sharing data.
Yes, so to the best of my knowledge, I've not seen a protocol being in place before the first bulk data exchanges.
You said in your earlier answer that it would have been better practice to do this, but plainly it was poor practice not to do it, given the significance of the voluntary disclosure of information which might otherwise be in breach of a secrecy provision. I'm suggesting it's poor practice not to follow the guideline by the ATO. Would you agree?
I would agree that the primary obligation on the protocol is in relation to the user of the data.
To the
I agree
extent that there was an obligation cast on the ATO by the protocol, it was poor practice not to comply with its obligation.
To the extent that there was an obligation put on the ATO under the guidelines, I would agree it is not best practice.
My words are poor practice. It's plainly poor practice.
The ATO should have to the extent it has not met the suggestions under the guidelines, it should have.
And you can't identify any reason why it did not.
Well, again, from my understanding and reading of the emails of those involved at the time, it is because it is the same data which has, from their perspective, not from a legal perspective, but from a functional perspective, the same data that has been historically provided.
And we dealt earlier with the fact that that was an assumption made by the ATO without taking any further step to satisfy itself by reference to the true facts or by legal advice.
So the ATO did not seek legal advice as to whether DHS's use of the data or through some form of audit of what DHS was doing with the data.
Ultimately, you would agree with me that the assumption made by the ATO about the use of the data was a flawed one, that it didn't reflect what in fact happened with the data. And we know that because we now have the Solicitor General's advice, we have the federal court cases, we have AAT cases, all of which said that the legal use, the purported legal use of the data was insufficient to raise a debt.
Well, again, I'm not sure if I fully agree with that comment, in that I think it's my understanding of that is that there is legal advice that the use to raise the debts was an improper use, an unlawful use. But to me, it does not follow from that the provision of data to Services Australia was an improper provision of data to Services Australia.
But to the extent that it may have been proper or may not have been proper was just a matter of chance, really, from the ATO's perspective, wasn't it?
Again, it was used for risk assessment purposes, and as far as I'm aware, there has been no suggestion that that is an improper use of the data.
When you say it was used for risk assessment purposes, what are you referring to there?
So what I'm referring to there is the selection of individuals for which further investigations would be undertaken.
But you now know, and it was obviously of concern to someone in the ATO in mid-2017, that the use, which was described in February of 2017 by Ms Golightly, might not have been accurate.
That a use may not have been accurate, yes.
We go to guideline paragraph 5.1. This is under the heading Notify the Public. Paragraph 5.1 identifies an obligation on the ATO before it participates in a data matching program to take reasonable steps to ensure a public notice of the proposed program is given. The ATO did not do that, did it?
I'm not aware of there being a public notice of the proposed program before it was carried, or before the ATO participated in the program.
Have you identified any steps at all which the ATO took in conformance with the guideline on data matching in Australian government administration under which it provided the data prior to providing the data?
I'm not aware of anything from my review of the documents.
And you can't explain why the ATO didn't?
Council, I've already asked to answer that question to the best of my ability.
The answer's no.
No, Council, my answer before was, you asked for the reason why we did not, and my understanding from reviewing the emails of the individuals involved at the time was because they viewed it fundamentally as a continuation of an existing data sharing mechanism. I would also note this was not a secret data matching program in that it was in a budget. So to the extent that of public transparency, it was available to the public.
Are you suggesting that the data matching program engaged in by the ATO and DHS was sufficiently disclosed to the public as a budget measure?
I'm not suggesting that, Council. I'm suggesting that you've asked me why these steps were not taken, and I've answered to the best of my ability.
Because of assumptions made that it was a continuation of a program.
That is, from my review of the emails, that is my best impression as to what was in the minds of the individuals involved.
But as you've said, the protocol applied, but it wasn't adopted or no action was taken under it.
I've not identified any action taken by the ATO under the protocol before the data was exchanged.
Would you agree with me then that the concerns which were still being raised within the ATO about the use of the data in 2017 in the emails we've just seen would have been more properly fleshed out had the guideline been applied? That is, protocols been published.
I would agree that if the agencies had gone through the discipline of preparing the protocol, there would have been an increased chance that the problems would have been identified.
And if the ATO obtained legal advice about the use to which the data was put, there would have been an increased chance that it could have assured itself that it was doing something lawfully.
So again, I think there's a different question here between whether the ATO's data sharing was lawful and whether all of DHS's use of the data was lawful. I think they're different questions.
Yes, my point is the distinction, to whatever extent it exists, would have been identified had the ATO sought legal advice about it.
So again, I think I will agree that it would have put the ATO in a position to suggest to DHS that they should have sought legal advice as to the operation of their Act.
You're saying that DHS really bore the responsibility for legal advice here?
As it relates to the operation of the social security laws, DHS, under both the legal guidelines that you referred to earlier and the head agreement, the primary obligation to get legal advice on the operation of the social security laws rests on DHS.
The primary obligation to get legal advice about the provision of taxpayer identification information rests on the ATO.
Yes.
And it didn't get legal advice about that.
It did not.
Again, that's just not a matter of good practice, is it? That's poor practice for the scale of the scheme considered here.
I would say absolute belt and braces best practice would have been to get legal advice, but fundamentally on its face, the information was relevant for compliance purposes under the Social Security Act.
This is the assurance you were given by people without anything that was reflected, any legal advice obtained by them or any protocol about what actually happened with the data.
Again, there is the head agreement and the supporting schedule which set out how they should use the data.
What steps did the ATO take after providing data to make sure that DHS used the data as it should have? That is, not for another purpose, a purpose not according to law.
So this is why we have the entire governance framework set out under the head agreement and the side agreement of the consultative forum, the data management forum, and the other bodies under that to talk about the use of the data.
Have you identified any step taken by the ATO, specifically in respect of the Robodebt scheme, about the use of the data?
Well, indeed, Council, I'd say all the meetings we have been speaking about, including the February 17 meeting, are exactly steps that the ATO took to assure itself that the DHS was using the data properly.
And we get to July 2017 and there still remains uncertainty on the ATO side about the ultimate use to which the data is being put.
Certainly from the email you showed me that at least one officer at the ATO has a concern in July 17.
And from the emails you've reviewed before and after that period, it seemed to be a valid concern.
Well, events have shown that there were valid concerns that a purpose to which the information was put should have been concerns.
And if we pull back from that, if you had been informed, as we've indicated earlier, that the purpose was to raise debts by averaging ATO PAYG data to increased compliance activity, and that was not according to law, the ATO wouldn't have provided the data.
Yes, so if we had been advised, as was a requirement under the head agreement and the side agreement, that the use of that data was unlawful, that would have raised significant concerns in the tax office. And indeed, from when the ATO, from my review of the emails, the ATO did become aware of the concern within Services Australia that it was unlawful in November 2019, and the ATO immediately expressed strong views about the continued use of the data.
Did it turn the tap off at any point when it had those concerns?
Yes, again, from my review of the emails, so of course the data had already been provided. The ongoing interaction in November 2019 was in relation to the garnishing of tax refunds by Services Australia. The ATO indicated that it would turn off all garnishees from Services Australia if it was continued to be given garnishees relating to debts raised under Robodebt.
What you've just described as a continuation of the provision of data up until it was identified by the other agency, Services Australia, that the use might not be lawful, was that the ATO was content to rely on the position adopted by Services Australia to it about whether the use was lawful or not.
Yes, so the ATO was happy to continue providing the data on the basis that Services Australia had an obligation to tell the ATO if there was any concern that it was not lawful.
And have you identified in writing a request in January 2017 for legal advice which supports the lawful use of the data by DHS? That is a request from the ATO to DHS?
Yes, I have not identified any request from the ATO to Services Australia about the lawful nature.
Even though it's clear from media reports at the time that the question of lawfulness was raised?
Again, I'm not familiar with the exact content of the media reports at the time. We did not ask a question about whether it was lawful. I have not identified us asking a question about whether it was a lawful use.
Not in January 2017, the following year, and up until November 2019?
I have not identified any request from the ATO to DHS to get legal advice.
And that put the ATO in the position, didn't it, whereby it was providing enormous amounts of taxpayer identification number without any legal assurance that the purpose to which it was being put was lawful? That is,
can I say, other than verbal assurances and the obligation to continue to comply with the head agreement.
But there was no obligation to comply with the head agreement, was there? The ATO chose on every occasion when it provided data that it would do so voluntarily to provide assistance to DHS.
So we provided data to DHS under the general statutory mechanism which permitted it, but under some form of contractual agreement, at least in the form of some sort of contractual agreement with Services Australia, which put obligations on Services Australia to proactively tell us if they had any concerns around the legality of how they were using the data.
I'll just pick you up on your form of language again. It's a phrase you repeatedly use. You say that you provided, as in the ATO provided data, under a legislative provision which permitted it to do so. But it's clear that there was a representation that it was permitted to do so, but no actual ascertaining of legally whether it was or was not.
The ATO did not seek its own legal advice as to every step that DHS took with the data, that every step that they used was lawful under social security law.
Or even the first step. It just didn't seek legal advice.
It did not, the ATO did not seek legal advice as to the operation of social security law.
And yet it provided the data anyway.
Yes, it provided the data.
No further questions, thank you.
Ms Hogendoren?
Commissioner, I have 3 brief topics. I think it may take about 15 minutes.
Sure.
Proceed.
Yes, of course.
Mr Hirschhorn, I have 3 topics I want to address with you. 2 concern the documents produced by the ATO and 1, some questions from yesterday morning, or yesterday. Could the witness be shown Exhibit 477, which is ATO 002 077 0503? While that's being brought up, Mr Hirschhorn, that's an email from the General Counsel of the ATO, 26 May 2016. And you'll see there in the second paragraph there's reference to AGS advice. It's with a capital A, advice. And you'll see in the following paragraph a reference, it speaks to the content of that advice, and then in the following paragraph it says, in the years that have passed. Could I show you, just pausing there, does that prompt you in any way as to what that AGS advice reference might be to?
So, Counsel, I've not seen that advice, but my reading of that paragraph is that there was advice from AGS about what particular things could be shared with Services Australia. Unfortunately, I have not seen that advice.
All right, could I have the witness shown a document produced by the ATO on the 27th of October, ATO.002.077.6418? Sorry, 0418. ATO.002.077.0418. You see, that's an advice from the Australian Government Solicitor dated 23 January 2003 with the heading Transfer of Information to the Data Matching Agency, brackets DMA, brackets under the Data Matching Program, brackets Assistance and Tax, brackets Act 1990. Have you seen this document before, Mr Hirschhorn?
I cannot recall seeing this document before.
Having regard to the General Counsel's reference to the years that have passed, is it possible that this is the advice to which she's referring?
I would strongly suspect that this is the advice.
All right, thank you. That document be taken down. You asked some questions in respect of some minutes of a DHS ATO operational meeting on 7 July 2017. Could the witness be shown Exhibit 283, that's ATO.001 644 8921. Not sure if it's going to come up, Mr Hirschhorn, but essentially that was an email referring to that meeting having occurred on the 7th of July 2017. Do you remember that passage of exchange with
I do remember that passage, yes.
Mr Gregory? Could we please go to another set of minutes, which is a document produced by the ATO, I'm instructed. This is ATO.001.957.2309, and we should be seeing Minutes of the DHS ATO Data Management Forum of 20 July 2017.
Do you happen to know an exhibit number?
No, Commissioner. So, Commissioner, just with respect to the AGS advice, which was the subject of my previous questions, and this document, subject to this question, they are documents produced by the ATO to the Commission, but are not in the exhibit list. But I take the witness to them for the purposes of clarifying the evidence that they've given.
Should they be made exhibits now?
If that's convenient to you, Commissioner.
Okay. I know every time I touch the exhibit list it causes an alarm and consternation.
If it's convenient.
But,
Yes.
sorry, what were you going to say?
It may be Exhibit 326 in the list.
The data forum minutes?
Yes.
What about the ATO advice?
No, I don't think the ATO advice is contained in the list.
Yes, Commissioner, my friend is right in respect of both matters. So, Exhibit 326, the minutes, but the AGS advice of 23 January 2003 is not presently exhibited.
Okay. I wonder if I can conveniently attach it to something.
Commissioner, you may...
How about I make it 505A?
505K?
A.
A.
A for Apple.
Thank you, Commissioner.
And it was from 2003, wasn't it?
Yes, 23 January 2003, the author appears on the final page, .0424. Perhaps we might have that document brought back up, operators. ATO 002 077 0418. You'll see that's a 7-page letter. And then, Commissioner, there is an attachment to that, which has a different document code. That is the way of our world. ATO 002 077 0460. That is an attachment that is referred to in the body of the letter.
All right, well, I'll make that 505B.
Thank you, Commissioner. That document might be taken down and we return to the exhibit 283, ATO 001 957 2309. If I could just have the witness shown, page .2311, which is the third page of that document. Agenda item 5, ATO/DHS operational meeting held on 7 July 2017 between DHS and ATO. Key items discussed included transfer of files, data integrity with files, variation to file formats, data availability, next meeting scheduled for 4 August 2017. Action items, no action items or decisions arising from this item. Do you see that, Mr Hirschhorn?
I do, Counsel, yes.
Is this a document that you reviewed prior to providing your statement?
Yes, this is one of the minutes of the Data Management Forum.
You provided in your statement minutes of a consultative forum and a data management forum, is that right?
Yes.
Right. Are we to understand from this that there is another layer or operational forum layer, or are these just ad hoc meetings and they reported in this way? Do you know?
Councillor, I don't know. I would have to have reference to the agreements to be confident. I think it is contemplated under the agreements.
And that's the agreements that were in place at least as at July 2017?
Yes.
All right. The final matter I want to raise with you is yesterday, if I have transcript, day 6, page 357, about line 30, shown up. You were asked some questions yesterday about the single touch payroll phase 1 and 2. You were also asked some questions today about in which you answered both in relation to the current position and in relation to the previous position during the Robodebt scheme. And I just wanted to get some clarity as to what is the current position, so that it might be drawn by way of contrast to the position in the Robodebt scheme. You were giving some, if I could just have that back up, thank you, operator. You were being asked some questions about paragraph 3.3 of your statement. It doesn't look like it's the right passage. Just one moment. So, operator, if you could just go back, we will get the hang of this. In the middle of the page, line 20, you were asked a question about the arrangements, and you told Mr. Gregory that there were agreements with Services Australia as to the use of data and stewardship of data, and to work progressively to implement that data for agreed use cases. You're referring to, are you, the position in relation to single touch payroll data exchange?
Yes.
Right. Could the witness be shown Exhibit 471, which is ATO 002 267 0051? And is that the abridged arrangement for single touch payroll strategic solution data exchange that is the current agreement that applies to data exchange with Services Australia?
Yes, in relation to STP data, yes.
In relation to STP data, all right. Just before we go into the body of this agreement, could you just explain what you meant by the concept of data stewardship?
Yes, so there's, if I maybe just draw a distinction between data sharing, which we've been speaking about, which is whether you have the, I suppose it comes often down to a question of legality as to whether you can share data or must share the data. The concept of data stewardship is an idea that as a provider of data, you must have, or you should have continued care over the use of that data and making over and above potentially legal rights in relation to controlling the use of that data. So data stewardship has as its concept the idea that as a provider of data, you should have continued a strong role in the oversight of the potential uses of that data by the agency or the person with whom you share that data.
And as you understand it, is the concept of data stewardship, does that inform this abridged agreement?
Yes, so I would say that the previous agreements had some rights and obligations in relation to use of data, but that this document, which is more recent, has a much stronger framework around the stewardship of the STP data than we had under the previous agreements.
And when you referred to a stronger framework, is it right to understand a stronger risk and governance framework?
Yes, by specifying, for example, by specifying agreed permitted uses, having a governance body to oversight those uses, but also to having an agreed mechanism for agreeing or disagreeing with other potential uses of the data.
All right. If I could just have shown up, if we could go to 0055, which under the heading 5, governance, and take in this page to the end of 5.3, we can see three bodies. The Joint ATO Services Australia Cross-Agency Governance Committee, that's dealt with in 5.1. 5.2, the STP Phase 2 Readiness Working Group, under 5.2, and 5.3 we see the STP Data Governance Group. Now, I appreciate that this is specifically applicable to single-touch payroll data exchange, but it's right, isn't it, that these governance arrangements of this kind were not in place during Robodebt?
Not nearly to the same extent, this is a much stronger governance framework around uses of data than previously existed.
All right, we go over to Clause 8, which is over page 0058, 0059, from 8.1 through to 8.11, but the one I wanted to particularly draw your attention to is 8.1. Clause 8 is responsibilities of both parties in respect to the information exchange. 8.1. Do the arrangements have this kind of specificity as to the allocation of responsibility for maintaining the integrity of data exchange during the Robodebt scheme, to your understanding?
Yes. So this is this arrangement is a significantly stronger version of the agreement which was in place during the Robodebt period.
All right, and lastly, under the topic heading Clause 9, Risk Management, on 0059, just the two clauses at the bottom of the page. 9.1, each party agrees in carrying out its obligations under this arrangement to apply the Commonwealth Risk Management Policy. See that clause there?
Yes.
Do you know if there was ever any consideration of applying that policy to the exchange of data for the purposes of the Robodebt scheme by the ATO and DHS?
I don't know, Council, I don't know even if that policy was in place at the time of Robodebt.
Thank you, Commissioner. That's all I wish to raise.
Thank you. Anything, Mr Gregory?
Mr Hirschhorn, again, just to clarify, the STP abridged agreement to which you've just been referred does not of itself provide any lawful basis to share data, but is an agreement in respect of the processes which apply to data which is shared, presumably lawfully.
Yes, indeed. As with all the agreements, they rely on the fact that there is a legal mechanism to share the data, and then they provide the rules of engagement in relation to the use of that data.
Are you aware of any development of protocols or processes around the legality of data sharing in the first place by the ATO which have been developed since the Robodebt scheme?
So, sorry, Council, can you say the question again? I'm not sure if I quite understood the question.
The STP abridged agreement, you said relates to processes where it presumes that the data has been lawfully shared in the first place, and you described it as a tighter process. My question is directed to whether the ATO has looked at how it ensures that in the very first place it doesn't, its decision to share data falls within the legal requirements or permits of the various legislation.
So again, I would say in one sense there is no change because we do not do some sort of proactive audit of the using agencies' processes and seek legal advice on their legislation. But we do have these processes which are meant to require the using agency to advise us if it is lawful or unlawful use.
I was more focused on the ATO's obligation to provide information lawfully. Has anything been done in that area by the ATO?
So again, the way we assure ourselves that is a lawful sharing is to gain comfort that it is for example, for the purposes of the Social Security law, in working out whether it is for the purposes of the Social Security law, we rely on, or the way we get comfort from ourselves is information through these frameworks that senior people in the recipient agency have, the position that it is for the purposes of their act. We do not double guess their position.
Nothing further?
Thanks, Mr Hirschhorn. You want Mr Hirschhorn excused?
Oh, yes, I should indicate I do wish him to be excused, but I've been informed that there are more documents being provided by the ATO in successive tranches over time. So for the purpose of the summons which he is currently under, it's appropriate to excuse
him. If there's any prospect he'll be wanted back in relation to more documents. It
Well,
doesn't mean he will be. But
Yes, well, we just don't know. We were happy to issue a fresh summons in that event.
okay. Would you like to be excused, Mr Hirschhorn?
It sounds good to me, Commissioner.
I bet it does. You're excused, thanks, Mr Hirschhorn. We'll adjourn till 2:30.
All rise. The Commission stands adjourned until 2:30 p.m. The Royal Commission is now in session. Please be seated.
Yes, Ms Marsh.
Thank you, Commissioner. I call Mr Robert Ashton Whelan.
All right, and we might have some appearances, I think.
Oh, my apologies.
Mr O'Brien?
We gave them leave to appear on the 28th of October. Mr Whelan is the witness. He's the general manager of that organisation.
Thank you. And Mr McMillan?
May it please the Court, my name is Macmillan. I appear on behalf of Ilian Australia Proprietary Limited, trading as Milton Graham, and Christopher Ross, who is the next witness. I'm instructed by Johnson, Winter and Slattery.
Thank you. Yes, Ms Marsh?
Thank you, Commissioner. My apologies. I now call Mr Robert Ashton Whelan.
And Mr Whelan, would you take an oath or an affirmation?
An affirmation, Commissioner.
Thank you. Would you administer the affirmation?
Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth? Thank you.
Yes, Ms Marsh?
Thank you, Commissioner. Mr Whelan, you were issued a notice by this Commission and provided a statement in response to it. Is that right?
Yes.
And in addition to the statement, ARL has produced about 11 documents.
I believe we produced more than 11, but...
I should say about 11 discrete files. Some of them contain more documents.
Yeah.
Thank you, Mr Whelan. Commissioner, in version 2 of the tender list, which I think you have before you,
I do.
you'll see exhibits 506 to 518, which contain those documents, which I tender.
All right. The documents will be given exhibit numbers from 506 to 518 in accordance with what's contained on the schedule. Mr O'Brien, you've got a copy of that, have you?
Yes, I have. Thank you.
Good. Thank you.
Thank you, Commissioner. Mr Whelan, to confirm, your statement, which is exhibit 507, and document ID ARL 999900010018 is 6 pages.
That would be correct.
Thank you, Mr Whelan. I'll ask the operator to leave that up for now. Mr Whelan, can you describe your role at ARL?
I'm the general manager, so basically I have oversight over the the financial performance of the business and also the strategic direction.
And how long have you been with ARL?
Since December 2018.
And what, have you always had the role of general manager?
No. General manager from December 2020. Prior to that, I was operations manager from August 2019.
Okay.
And originally client liaison manager from December 2018.
And what did you do before that?
Before that, I was with a company called Landmark.
And what was the business of Landmark?
They're an agricultural company.
Okay. Can you describe the work of ARL?
We are a contingent debt collection company.
When you say the word contingent, what does that mean?
That means that we collect debts on behalf of a client rather than purchasing a debt and collecting it on our own behalf.
So is it right to say that a client would refer a debt to you?
That's correct.
And what sort of clients might you engage with?
We have clients from Big Four banks, government agencies, obviously, and generally telco utilities, sub-insurance companies, things like that.
And DHS is one of them.
That's correct.
Can you describe, I withdraw that, can you explain to me whether ARL is a member of a group of companies?
We do have a parent company, yes.
What's the parent company?
We're part of the Panthera group.
Panthera Group. Okay. Now, you've given evidence that ARL has a relationship with DHS.
That's correct.
And can you recall when that started?
I believe it was around June or July 2017.
Can I take you to Exhibit 513, which is one of the schedules that you were referring to. And can I take you to page 110 of that? So for the operator's benefit, _0110. I think 0110. Fortunately, it's cut off a little bit, but I think we're a bit further down in that document. Further down, operator, it's 0110. Great, thank you. Now, this is one of the multiple contracts that have been provided by ARL. And you'd accept that.
Yes.
And can I now take you to 0121, which is further down in the same document. And you'll see there's an execution date of that document, which is the 8th of February 2016.
Yes.
And is this likely your ARL's first engagement?
Potentially, my understanding is that we first started collecting in around June or July of 2017.
Okay.
So this contract may have been signed earlier, or but there would have been a transition in period, I'd imagine.
Okay, but you'd accept that this is, and perhaps if the operator can go back to 0110, you'd accept that on the face of this document, it's a deed which would govern an arrangement between ARL and the Department of Human Services.
Yes.
And my apologies to the operator, I'm going to have to take you back again to 0122, which is the page after the execution page, which provides particulars. And I'll take you to paragraph 3.1. And I'll ask if that can be drawn out, which is the scope of the work. So you'd accept that under this deed, work is envisaged to be done by ARL to recover outstanding debts.
Correct.
And that the minimum amount of those outstanding debts would be $20.
According to this, yes, correct.
Well, and I can take you to 1.1 as well. Which reaffirms the idea that a minimum debt would be a debt of $20.
Yes.
And then can I take you to 1.2? Which provides some information about the department. Would you accept that, based on that paragraph, in the 2014-15 financial year, it's estimated that 323,000 debts were referred by the department?
That's what it says, yes.
Yes, and the total value being over 330 million?
Correct.
And Mr. Whelan, you're familiar with the Robodebt scheme?
I am, yes.
And you'd be familiar with the time period of that scheme?
Yes.
And can you tell me what that time period is?
My understanding was from 2016 through to towards the end of 2019.
That's right. And so that information predates the scheme. And this was signed before the commencement of the scheme, but was ongoing during it.
I believe so. I wasn't with the company at the time, but yes, it looks like it from that document.
Okay. So what I'm trying to establish is that this is the contractual regime which we need to look to govern the arrangements between ARL and DHS.
Yeah, yeah.
Mr. Whelan, do you know the sorts of debts that DHS refer to ARL?
Typically, it's along the lines of JobKeeper and family tax benefits, so basically support payments, things like that.
Okay. When those debts are referred, can you identify either the type of debt or the referring organisation?
We can obviously identify the referring organisation. We can identify the type of debt, but not how it was raised.
Okay, so you would be able to identify the type of social services payment that a debt corresponds to?
Correct.
You would have that information?
Correct.
And would your call operators have that information?
Yes.
Okay. And would your call operators also have information about the referring agency?
They would know that they know the client that they're representing, yes.
Okay. I'll take you back to your statement, which is Exhibit 507. If we can go to paragraph 16. In light of what you've just said, can you explain the words, "These debts were referred to ARL," in a manner making them indistinguishable from other referrals?
As I said, we're not privy or we have no visibility over how a debt was actually raised, whether it was as a result of this scheme or other processes that Services Australia were using.
So the other referrals you're referring to are other DHS referrals?
Correct. I believe in the definitions of this document, it specifically said debt referred to debt raised by this scheme, and so we needed to make the distinction that...
So your operators can't tell whether there's a Robodebt, but they can tell that there's a DHS debt?
Correct.
And once they know that there's a DHS debt, what do they do differently?
They follow the same process. We have a team who are dedicated to actioning the Services Australia accounts. So they follow the process set out in our call scripts and our workflows.
Okay. You say you have a team of people who deal with DHS debts,
Correct.
and they follow particular processes in respect of those debts.
That's correct.
Can you explain to me how they know what processes to follow?
Before we go live with the client instructs us on what we can and can't say on a phone call, and that's set out in our actual call script. They also dictate what correspondence we send, what we can put in our letters, what we put in our text messages and our emails.
So DHS provides supervision as to the way debts are pursued?
Correct. They have to approve all our correspondence and all our actioning or proposed actioning before we can actually put it into production.
So they provide instructions?
Correct.
As to the general approach to debts?
Yes, that's correct.
Can I take you further to paragraph 16? The second sentence, you said ARL had no instructions from DHS specifically regarding the approach to the recovery of the debts. You're saying there are no instructions in respect of the Robodebt?
Nothing specific to
Okay.
Robodebt, no, just to referrals in general.
Okay, I understand. Can you explain to me the practice of double headsetting?
We don't actually call it that, but it's basically when somebody sits next to you and listens in on an actual call. So it's a live listening call for quality checking purposes, basically.
I use the phrase double headsetting because in your statement it's used in paragraph 18.
That's correct, because that was the terminology used in the document we received.
Right.
The Commission.
And is that the phrase used by DHS?
I believe so, yes.
Okay. Can you explain how that practice is adopted within ARL?
Typically, we do it on our own in terms of call calibrations as well, and we have our quality team listen on actual calls. With Services Australia, they would also engage in that practice when they came down to the Melbourne office.
How often does that happen?
My understanding is that it's meant to happen bi-monthly. In the period that I was actually involved with Services Australia and had oversight of it between August 2019 and April 2020, I'm only aware of them having come down once for that process. But to be fair, prior to August, it may well have been the case that they came down more often.
Okay, so DHS approve communications
Yes.
and engage in a practice whereby they listen to telephone calls.
That's one means of quality checking to make sure that we're acting in alignment with the approved processes.
What are the other means?
They do random file audits. They have access to our system to randomly look at accounts and check the actioning on them. They also engage in a monthly call calibration where they'll listen to a random sample of calls that they ask for from us. Both parties will listen to those calls and then come together in a meeting and discuss what could have been done better, what process improvements there could be and things like that.
How do they give you feedback?
During the actual meeting.
Do they ever give it to you in writing?
In writing, if it's something that's more of a specific change to our actual process, yes. They also we fill out, there's an actual call calibration checklist effectively, or scorecard.
Okay. And also at paragraph 18, you refer to training sessions.
Yes.
So is that another method of quality control?
In the time that I was there, they came down and did engage in basically refresher training for the staff members on their team, yes. Outside of the training that we provide as well.
Okay. Are you able to speak to those practices during what I'll call the Robodebt period?
Not really, no. I wasn't involved
Okay.
prior to August 2019.
Okay. Is there someone at ARL who could?
Potentially. I believe the team leader that we currently have has been involved with the organisation for several years, longer than me.
Okay. I'm going to take you through some of the documents that we use in the debt collection process. But before I do, I just want to confirm at paragraph 10 of your statement, you say there were no substantive or material changes to the debt collection process that applied to the debts.
Correct.
So it's safe to say there's a reasonably consistent approach.
Correct.
And how are you able to provide that evidence if you were not at ARL for most of that period of time?
Because we keep all our call scripts, all the correspondence that we've actually used on file, and I believe they're the documents that we've actually provided.
And you've reviewed those?
Yes.
And in your view, there are no substantial changes between them?
Not significant changes, minor changes to wording in some of the letters.
Okay.
To promote engagement with customers, but that's all.
I'll take you now to one of the other appendix documents provided, which ends in 0009 and is Exhibit 514. And I'll go to page 0126. And though it's a bit difficult to see, this seems to me to be a Services Australia document, is that right?
No, that's our workflow for the Services Australia accounts.
So you've prepared this document?
Correct.
Have you provided it to Services Australia?
Yes, all
And-
the workflows are approved as well by the clients before we put them into practice.
And Would you have provided by email?
I honestly don't know how we would have provided it at the time.
I understand. You can see the column down the side of the page has a number of days,
Correct.
and those go from day 1 to day 76.
Yes.
And so the anticipated process on this document is about an 11-week process.
Effectively, yes.
And would you anticipate that the process would be completed by the end of that?
Depends on what you mean by completed.
What does workflow complete mean?
Workflow complete means that process of a combination of calls and automated correspondence is finished. At that point, we can still do ad hoc call campaigns and things like that to contact customers.
When you say finished, do you mean that the dispute is resolved?
It's not related to a dispute. It's in relation to the process of trying to engage with the customer.
Well, do you mean that the debt has been satisfied?
No, it just means that workflow is complete.
So there might be another workflow that follows?
No, there's no other workflow. After that workflow is complete, contact attempts that are made with the customer are generally by phone.
And is there no guidance document that follows this?
Only in the sense that the phone calls cover the same scripting that is approved for all these phone calls that are on the workflow as well.
And who decides when to make those phone calls?
The team leader.
So the team leader has discretion after 11 weeks as to how to handle a debt referral?
No, as to whether to make a phone call on that account or not.
When would you say that a referral is complete?
Either when the amount's been paid or if the account's been recalled.
Okay. But when you say complete in that sense, you don't mean workflow complete in the sense used in this document?
No.
Okay. So this anticipates the first 11 weeks of your process, but not after that?
Correct.
Okay. In any event, you can see that there are a number of steps by day, and the first is on day 1, further contact on day 2, further contact on day 4, then 13, then 22, then 29, then 32, then 40, then 36, then 61, then 76.
Correct. Attempted contacts, yes.
Attempted contacts.
Obviously, if we engage with the customer at day 4 on a phone call, that workflow effectively stops if they make a repayment arrangement or if the debt's disputed.
And is this workflow broadly similar to the sorts of workflow you'd see with other
Yes.
clients?
Yes.
So big companies?
Yes.
In your view, is this a fairly standard trajectory of a referred debt?
It is, yes.
Take you to the next page. And I should say, on the bottom of the page, which is difficult to see, Mr. Whelan, but if you can see it, I'd be grateful if you could confirm that there are the words final approval date, 7th of July 2017.
Correct.
So we can anticipate that this was in force from around that time. On that page, I'll also ask to be drawn out a number of the different types of DHS payments and services that this governs. You'll see New Start, Youth Allowance, Oz Study or Ab Study, and a variety of other services. And you agree with me on that, Mr. Whelan?
Yes.
And I'll now move on to the reasons for overpayment. And you'd agree that The first is incorrectly declaring income or assets.
Yes.
And this document, I understand, would be provided to your call operators.
That's correct. I believe this is the call script used at the time.
Great. So they would be aware of the sorts of payments and the sorts of reasons that have been posited for the debt.
Correct.
I'll go to the next page, which is 128. And I'll just draw out the first sentence, which says that the expectation is that a payment of a debt should be made in full by the due date. Only where there is no capacity to pay in full should an arrangement be considered. Is that correct?
Correct.
And it is the due date, the date of completion on the workflow that we saw?
No, the due date I'm imagining here is in regards to potentially the first letter that we send with the amount that's due. Yeah.
Can I confirm, is the workflow that we saw about making first contact?
Effectively, yes.
Okay. And so the debt collection process would follow first contact following the workflow?
That's correct.
Right.
If we get hold of somebody on day 4 and engage with them and they make a repayment arrangement, we basically don't really contact them again as long as that arrangement's being maintained.
I'll move on to page 130. Collections hierarchy and strategy. Point 3 suggests that it is necessary to negotiate a payment arrangement for the remaining balance with the arrangement start date expecting to take place immediately. Immediately is underlined. So there's a certain time imperative to recover debts?
Yes, generally.
Noting the sorts of payments that are currently being recovered.
Yes.
And the next paragraph says, when negotiating repayment offers, it is important that the following is not disclosed. Minimal acceptable amount, minimum acceptable period, and that discounts are available. So when negotiating payment plans, none of those things are disclosed?
Not initially, no.
When are they disclosed?
When we have the Services Australia's approval to do so.
So you can only negotiate a payment plan with DHS approval?
That's correct. Well, for less than those minimum amounts, yes.
Right. And the minimum amounts are, I think at page 134. Are they the minimum amounts you're talking about?
Correct.
So you have a writing authority to negotiate payment plans consistent with that, but you would need approval
Correct.
otherwise.
Can I just ask what discounts were available?
I'm not actually sure, to be honest, Commissioner.
Thank you.
If I could now go to page 131, so stepping back. You'll see the row titled Consequences and Benefits.
Yes.
To draw out consequences. Are these consequences that would be communicated by your call operators?
We are required to notify them of the consequences, yes.
Okay. And those consequences are continued telephone calls or letters?
Correct.
And recovery action such as garnishee action? And legal action for the recovery of a debt.
Correct.
And departure prohibition orders. Can you explain departure prohibition orders?
I can't. I believe it prevents the customer from being able to travel overseas.
And there's also an interest charge. And the benefits that your operators must communicate are listed. Is that right?
Yes, correct.
And they're things like one less debt to worry about, and the phone calls and the letters will cease. Is that right? Thank you, Ms. Whelan. I'll just need you to say yes. My apologies.
Apologies, Councillor.
Thank you. Are your call operators also required to communicate the disputes process?
That's correct, if a customer disputes the debt.
And I think I'll take you to 144, which identifies the options available.
For disputes down the bottom, yes.
Which include negotiating a repayment arrangement. So that's the payment plan option we were talking about.
For any amount that isn't in dispute, but only for an amount that isn't in dispute.
Yes. Does that mean that even if there is a dispute as to the legality of a debt, you would still be pursuing payment and negotiating a payment plan?
No, as soon as the customer disputes any or all of the debt, we follow this disputes process.
And how does a customer dispute a debt?
If they actually say it to us on the phone that they don't believe they owe the money, then we follow this disputes process.
Can you explain that process?
Yes, we put the account on hold and they're referred back to Services Australia.
Okay. And is that an automatic process?
Putting the actual account on hold is an automatic process, or action by the agent at the time. What the customer does in terms of contacting Services Australia, I couldn't tell you.
So they say, I'm disputing this debt, and you put it on hold?
We put it on dispute hold, yes.
How long is it on dispute hold?
Initially 5 to 7 days. The instruction, at least in more recent times, has been that the customer contact Services Australia and then call us back with the actual reference number or the appeal number.
So during
At that point, we put it on hold permanently until the dispute's resolved.
So during what I'll call the Robodebt period, you have the words diarised date 7 days. And so a customer would say, I dispute this debt,
Yes.
put it on hold for 7 days.
We advise them at the time to contact Services Australia and then come back to us with the reference number for the dispute. And we diarise the account for 7 days effectively. So if we haven't heard back from them or the account hasn't been recalled by Services Australia, then we'll follow the customer up to find out whether they disputed the amount or not.
Okay. 7 days isn't a very long time.
They only need to call Services Australia.
And would that have been a prescription by DHS?
Everything that we do is governed by our clients, so yes.
And so if you heard nothing, you would put the debt back on your normal debt collection process?
It would come back in for a call, yes, to follow the customer up.
And the only thing that would stop that from happening is if there was a customer reference number with DHS?
If the customer called us back with the reference number, yes. Or if Services Australia themselves recalled the debt.
So in a sense, either the customer or DHS have to satisfy you that there is an ongoing dispute?
That not satisfy, I don't believe that's the word, but yes, they would. One of the two needs to notify us, yes.
So in effect, a customer has 7 days to communicate to you that there's a dispute.
No, they've got 7 days to come back to us with the dispute reference number after they've contacted Services Australia.
Which indicates to you that there's a dispute.
Yes, other than the fact that they would have told us on the phone in the first place, that's what triggers this process.
I'm trying to understand what a customer has to do in a particular period of time in order to prolong that 7-day period.
Effectively, to prolong it,
Yeah.
if they called us back and said they were still struggling to get through to Services Australia on the phone, then we could potentially re-diarise the account.
When you say potentially, who makes the decision?
The decision would generally be made by the operator at the time or with the approval of the team leader.
So is that a discretionary decision by the operator?
It would be, I believe, yes.
And when does their team leader get involved?
If the customer wished to speak to a team leader, then we could,
Okay.
then we'd escalate the call, yes.
Okay, so how hard and fast the 7 days is depends on the telephone operator.
I don't believe we would ever have had a situation where a customer hasn't been able to get through to Services Australia on the phone for 7 days
Okay,
or for a period of longer than a day.
okay. I'm going to take you through some of the standard form correspondence, which are in that document, but they are at page 87. Now, am I right in thinking that a document titled Collection Notice is the first contact after the initial, let me rephrase that, there is some form of initial contact made and then there is communication in this way. Is this the first formal contact as to the debt?
Typically upon referral, as per that workflow, there'll be a text message sent to the customer, and I believe this is the next step in that workflow is a collections notice would be sent out.
And so can I draw out, after the words, what can happen if I don't pay, under frequently asked questions? There's a list of the sorts of consequences we spoke about before. So they're things like garnishing your wages. I'm sorry, Mr. Whelan, can you say?
Yes.
And legal action.
Yes.
And a departure prohibition order.
Yes.
So those things are communicated at the first formal communication.
Correct.
And I'll now go to page 90, which is just a few ahead. Which is the second collection notice.
Yes.
And under frequently asked questions, which I'll ask to be drawn out again, you see the same sorts of things.
Yes.
And I'll take you to one more, which is at page 99. And the bullet points say similar things.
Yes.
I'll take you to page 124. Which is very small and difficult to read. By my reckoning, there's about 18 rows. If it doesn't make you go cross-eyed, I'll ask you to count them.
Right. 2. Yeah, 18 looks right.
And is that roughly what you can see?
Yes.
And would a single customer Is it feasible that a single customer could receive all of those text messages?
No, they're all, if you notice on the the columns on the right, they're the dates that the actual SMSs were inputted into our system.
Okay.
So it's basically, again, just as we referred all the letter templates that we've used during this period, we also referred all the SMSs that we used during this period.
Okay. And so those would have been approved by DHS?
Correct.
And any one customer may have received any number of them depending on their circumstances?
Potentially, yes, depending on their circumstances.
And the person who decides how many of them you receive is the call operator?
No, that's governed by the workflow. These are all issued by that workflow that we had up earlier.
Okay.
And that's what I was referring to in terms of workflow complete. It's when it's gone through these automated and set out periods of processes, basically.
Okay. I'm going to take you back to that training document we were looking at before, to page 139 of this document. And you'll see there that the column identifies what an operator should do when threats of self-harm or harm to others are made.
Yes.
Is that something that happens frequently?
Not frequently. More often than I'd like.
But frequently enough that there's a need to have that as a part of the process?
I believe it's responsible to have these sort of instructions in every call script, and we do have them in every call script for all our clients, yes.
And there's a process identified if those threats are made?
Correct.
And it's incumbent upon your call operators to put that process into action?
Yes.
And if we go to the next page, there are similar indications in respect of vulnerable customers.
Yes.
And again, it's up to your operators to identify vulnerability.
Yes, they do receive training for that though as well.
And then if we go to the next page, you'll see another category which is significant, which is hardship.
Yes.
And again, it is up to your call operators to identify hardship.
Correct.
And a hardship application might be made.
Yes.
And what does that process look like?
Generally, we would, again, take the details of the actual customer and refer it back to Services Australia. We would also complete, in certain circumstances, a statement of financial position, just so that Services Australia are in a better position to decide what action they were going to take in regards to that customer's amount.
And would that factor into the negotiation of a payment plan if it is inconsistent with your minimum agreed amounts?
We've never accepted, we've always accepted, I should say, even arrangements below the minimum amount. But in the case of actual hardship at any of these circumstances, that's at the discretion of Services Australia.
When you say we've always accepted,
ARL.
ARL has always accepted
Correct.
hardship.
So we've never had a repayment arrangement offer that was lower than the minimum acceptable arrangements. We've never had that declined by Services Australia.
Okay. Mr. Whelan, you mentioned before that ARL is a subsidiary of Panthera Finance.
We're part of the Panthera Group, yes.
So Panthera Finance Pty Ltd is your parent company?
I believe so, yes.
Are you familiar with a federal court case in 2020 involving Panthera's debt collection practices?
Vaguely aware, if
Vaguely.
the ACCC or federal court. ACCC.
That's the one I'm asking about. Are you aware of that one?
I am aware of it, yes.
And so you'd be aware that in that case, Panthera had admitted that between the 22nd of September 2017 and the 9th of October 2017, and between the 29th of June 2018 and the 14th of July 2018, Panthera had engaged in undue harassment associated with debt collection practices?
I'm aware that there were a handful of cases and that it was found that it wasn't systemic or part of Panthera's normal business practices and that it was isolated to certain operators.
But that it was a contravention of the Australian consumer law?
Correct.
And that it involved undue harassment
Correct.
associated with debt collection?
Yes.
And misleading and deceptive conduct?
Yes.
And that the time periods were 2017, 2018?
I wasn't familiar with the time periods until now, but yeah.
And you'll be aware then that in that judgment the words, the conduct was described as repeated and intrusive?
Yes.
And has ARL responded to that judgment by taking any internal...
ARL are a completely different company and are engaged in a different sphere of collections.
Okay.
So again, that's Panthera, a debt purchase company, and ARL are contingent.
Okay.
So they're collecting on their own behalf, we're collecting on behalf of our clients.
Have you reflected upon your practices?
To be honest, we were engaged by Services Australia prior to even being purchased by Panthera. We don't believe that our practices are... we believe that our practices are fair and reasonable.
And can I ask, whether information that's emerged about the Robodebt scheme has caused you to reflect upon any of your internal practices?
Not really. As I said, we had no visibility of how those debts were raised or whether it was reasonable to assume we had some referred to us. But again, we believe our practices are consistent, they're fair, they're reasonable. If there is grounds for a customer to dispute a debt, we have a process in place for them to be able to do that.
And your processes are all otherwise approved by DHS?
Correct.
I've got nothing further to ask. Thank you.
Thanks, Councillor.
Mr O'Brien?
Commissioner.
Do you wish Mr Whelan excused?
Thank you, Commissioner.
You're excused, thanks Mr Whelan.
Thank you, Commissioner.
Yes, thanks Mr O'Brien.
Commissioner, I call Mr. Christopher Ross.
Oath or affirmation?
Affirmation.
Thanks. Affirmation.
Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, Mr. Ross. Can I ask you to, oh, my apologies, before I do, Mr. Ross, you have been issued a notice in the course of this commission, is that right?
Yes.
And you've prepared a response to it?
Yes.
And you've provided a number of documents as well?
Yes.
Commissioner, documents identified as exhibits 519 to 830 are those documents, and I tender those.
Yes, they'll clear those numbers in accordance with the schedule, 519 to 830.
Oh, my apologies. My apologies, Commissioner. I withdraw that. I have tendered more documents than I had intended to. The final document relevant to Mr. Ross is numbered 712. I withdraw the subsequent documents for now.
712, thank you.
In any event, Mr. Ross, can you tell me about your role at Ilion?
Current role?
Yes.
My current role is Head of Compliance within Milton Graham, which is our collections department.
And you had some prior roles as well, if you could tell me about those.
Yes. So perhaps maybe recent to, yeah, so prior to the...
Perhaps let's say after 2016 onwards.
Okay. So I think through that period of time, I would have still been part of a contract manager role at the time. And that held that role until around 2020, I think it was around November, and then moved into a Head of Client Success role before recently becoming the Head of Compliance, which was March 22.
And can you describe the work of Ilion?
Yeah, we provide a range of different services, one of which is debt collection services. But in addition to that, we also operate some credit bureaus, both commercial and consumer, as well as offering some marketing services.
And can you describe for me your customers?
We've got a variety of different customers who use the services. Perhaps if I specifically focus on the debt collection industry,
Yes.
or the clients that we offer services for that.
Thank you.
A range of different clients, both from government bodies, state as well as federal, through to corporates, as well as individuals.
And the sorts of corporates that you work with, are they big companies?
There are big companies as well as small companies.
Okay. And can I ask you to explain the trading names that are relevant to Ilion, because there's been a few.
Yes. Yeah. So initially we traded under the name of Dun & Bradstreet.
Yes.
And then I think it was around 2018, that company name changed to Ilion. And as part of that, subsequently, we also operated under the trading name in our collections area of Milton Graham.
Thank you. One of your customers is the Department of Human Services,
Yes.
and can I take you to what is Exhibit 524, which is document ID MGR.0001.0001.0052. Now, you've identified in your statement that this is the deed of agreement that governs your relationship with DHS during the Robodebt period.
Yes.
And for clarity, the Robodebt period, can you tell me what your understanding of the Robodebt period is?
Approximately the June 2016 through until, I think it was late 2019.
Thank you. Now, can I ask you to go to page, or I'm not asking you to go to page, I'm asking the operator to go to the page, but we'll all go to the page, which is numbered 71. And you'll see part 18 is the calculation of fees. And you'll see there that a blacked out commission figure is identified, is that right?
Yes.
So there are commissions that attach to the work that you do with the Department of Human Services.
Yes.
And those are calculated as a percentage applied by the supplier on the amount of debt successfully recovered.
Correct.
And if I could trouble the operator to go to page 64. And the first line of 1.1, you'll see that the minimum debt recoverable pursuant to that agreement is a debt for about $20. That's right?
Yes.
Can I ask, Mr. Ross, your call operators, when they are processing a debt, can they see that a debt has come from DHS?
Yes.
But they wouldn't necessarily know whether a debt is a Robodebt?
No.
Okay.
In saying that, so the debts when they're referred will have different debt codes.
Yes.
And some of those codes we understand or understood, understand now, were linked to Robodebt matters.
Okay. At the time, would they have known that those debts had been generated automatically?
During the course of the entire period
Yeah.
of time, maybe not initially, but potentially later.
So they might have seen things about Robodebt in the news and been able to apprehend that this might be one of those debts?
possibly.
Okay. Am I right in saying that the Department of Human Services supervises very heavily your debt collection practices?
Yes.
And in what ways would they supervise those practices?
Through call monitoring,
Yes.
file reviews,
Yes.
as well as, I guess, investigating any matters or complaints that may get raised.
And when you say call monitoring, how often would that practice happen?
It varied through the period of time, and I've referred to that in my statement. There were different activities performed by DHS in conjunction with, while during QBR meetings, there would be times where staff members would be allocated some time to come and sit on the floor with our team members and do double heat sitting or double jacking, as we refer to it. They also then subsequently, and I think the dates escape me, but they're listed in my statement, would attend our office on bi-monthly occurrences and then again perform the similar double head setting or double jacking as we refer to it. And then also more later in the piece, they introduced a process whereby we would provide them a list of all the calls and contacts that we'd had for a particular period of time. They would then select calls themselves for which we would produce those and provide them through. They would then run a quality assessment check against a call quality framework, essentially, and provide us with the results from those.
So they would do things like listen to your calls and provide feedback?
Yes.
And would they also approve the communications that
Yes.
you had, the standard form communications that you had with customers?
Yes.
And you would have ongoing discussions about those?
Yes.
And so would the process look something like this? You might draft something and send it to DHS and they'd approve?
Yes.
And sometimes DHS would say, this is how we want that to be phrased, or we want this message to get out.
Yes.
But there were few standard forms, or there were few forms of communication that hadn't been approved.
Correct. Yes.
And the sorts of communications that perhaps wouldn't be approved would be the sorts of things that are at the discretion of the call operator.
Yes.
And those are the sorts of things where they make a decision on the phone, reflecting upon training they've received.
Yes.
And that training they would have received from DHS.
And or internally from our team as well.
And do you have a team of people who work on DHS debts?
Yes.
And do they have particular codes that they work on? So, for example, would somebody do lots of youth allowance calls, or are they delegated or allocated by customer?
It's at a client level.
Okay.
Can I just ask, who are your call operators? Where do you draw them from?
Where do we, sorry?
Where do you find your call operators?
We generally will just apply, advertise for
So
roles.
they're local people. Where are your centres?
Oh, sorry, yeah, we're based in Melbourne, and that's where the work is provided for DHS.
And how are they paid? Is it a fixed rate or a commission on what they...
It's a mix of both a base salary as well as a incentive.
A base salary and an incentive. What's the incentive?
Effectively, a bonus per se, which is available each month if they hit their relevant KPIs.
And what are the KPIs?
Predominantly two key ones would be a collections target.
Sorry? Collections target?
So an amount collected by an operator. But then there'll be a caveat for that to ensure that there has been no breaches identified during the month, at which point, if there is a breach identified, typically that would result in the operator not being eligible for a commission for that particular month.
How's a breach going to be identified?
Excuse me?
How is a breach going to be identified?
Whether it be potentially raised off the back of any complaint or also through any QA reviews that are undertaken.
Sorry, I didn't get the last bit.
Sorry, any quality assurance reviews that are undertaken either by the DHS or potentially also by our team leaders.
So that's somebody listening in on the calls?
Both live as well as potentially post calls.
Okay, that's not done for every call, I take it.
No.
All right. And your company works on commission on these debts too?
Yes.
So the financial imperative presumably is to recover as much as possible, as fast as possible?
Yes, but doing so in a compliant manner.
Right. Thank you. Ms Marsh?
If I can go to document MGR.0005.0001.0135, which is Exhibit 605. Mr. Ross, you might recognise this document as the document that's been produced in the course of your response. Do you have any? Is this your document? Do you have any involvement in this document?
Myself, personally?
Yeah.
No.
Can I call up the lighter coloured paragraph which starts feedback? My apologies. I was looking at the one at the bottom of the page. I'll read the words, which are, the warnings were not provided even though customer was only confirming the arrangement had been set up. The customer should have been reminded of the warnings if she were to break the arrangement. Now, I'm conscious that this isn't your document, but do you have any indication of what this document is doing?
Yes. It would be effectively providing feedback from the assessment of the call, or a call that was undertaken.
And so is this one of those calls where someone from DHS is listening in to one of your call operators' phone calls?
I cannot recall if that is a feedback that's been provided through from a team leader or whether it came from DHS, sorry.
Okay, but someone provided that feedback?
Yes.
And that's an example of the sort of feedback that you might receive or that your call operators might receive in one of those situations where there are multiple people on a call?
Sorry, where there were multiple?
Where there are I'll use the phrase. Does the phrase double head setting? Does that?
Double head setting. Yes. Look, that could have been the case, and that there was a double head setting event taking place, or alternatively, it could have been feedback that was provided from a review of a call that had taken place in the past, whereby the team leader had reviewed it post that call.
So, in any event, somebody who is in a position to provide feedback has listened to a call and has provided that particular feedback?
Yes.
Okay. Can you explain to me, just so that I understand all of the variations of supervision, what a call calibration is?
So a call calibration is typically where we would select a call. That would then be shared with a client as well as a team leader or a team of people internally. Each person would typically independently assess the call and then through the QA framework, and then effectively come back together and review each other's results in terms of that particular call to effectively calibrate it to see if the way that we might be measuring a call against the framework is accurate or similar to the way that our client might mark it as well.
So would call calibrations usually have the client involved?
Sometimes yes, but it could also involve an internal call calibration where our own team leaders would be asked to follow the same exercise to again assess the team leader's way of marking and whether they're aligned to the framework.
Okay. The reason I ask is because if we zoom out, you'll see the words call calibration, and I wondered whether
Royal Commission is now in session. Please be seated.
Now, can you go back to where you were looking at that transcript, asking about the words call calibration?
Thank you, Commissioner. I think I can be heard now. Before I do, I should say that it's been brought to my attention that my hand-numbered exhibits, done very lovingly, are one out.
So where are we now?
So the document that we're currently at is 606, but I had referred to it as 605, but I had used the correct document ID such that it could be called up. Mr. Ross, having spent some time working through the variations of supervision received by DHS, I'd like to shift to the process that Ilion engages in to collect debts.
You didn't want to ask that call calibration question? It doesn't matter.
Oh, thank you, Commissioner. For clarity, and so that it's on the transcript, can you please confirm with us what the meaning of the phrase call calibration is?
So effectively, it's where we get, often this is done with our clients or it can be internally with staff members, but essentially a call is selected, it is shared and independently marked based on the QA framework. That could be either a client's or our own internal. The results are then, from each person's individual review, are shared and effectively calibrated, so discussed to ensure there's some consistency and alignment in terms of the way that these calls are being assessed and measured.
Thank you. And one variation of that would be to have a call calibration including with the client, in this case DHS.
Yes.
I'll now move to process. And I'll take you to your statement, which I will now correctly describe as Exhibit 521. And if I could take you to page 8, paragraph 3.
Doesn't.
The document ID is MGR quadruple 9 0001 0002 _R. And the numbered page is 8, the numbering at the bottom of the page, and the paragraph is 3. And in that paragraph, you identify initial communications. And can I confirm that an initial communication is after a debt has been referred to Ilion?
Yes.
And that would be the first contact with a customer?
It would be the first initiated contact, yes.
And it seems to me from that paragraph that there are 2 tracks. Am I right in saying that there is a collection path and a treatment path?
Essentially, they're one and the same. I guess terminology.
Can you explain then what that process is to make the initial contact?
Okay, yeah, certainly. So there might be 2 situations. So one, we could have a new account or a new debt referred for an individual whom we have no past record of having another DHS matter, in which case we would create a new record or a new debtor record for that individual. The other situation would be where there is an existing account for an individual with existing active or overdue matters for which we're acting upon the DHS's behalf to collect, where a new invoice is added onto that customer's record. And essentially, there's two different approaches. So for the instance of a new account or where we haven't got any other active matters, essentially an initial demand letter will be issued out to the customer to the address that's been provided. And then after that, subsequent actions will be taking place and scheduled to take place into the future, which could also include phone activity as well as SMS activity in the event that there's a mobile number that's available or shared as a contact point for the individual.
How does Ilion know that a customer has received that contact?
Well, there's no definitive delivery confirmation in the event of a letter being issued. We do track, however, if return mail is received from an address so that we know that the address potentially is not the right address in terms of any future communications, but it is dependent on us receiving the letter back.
Okay. And so is the first contact usually in writing or is it a phone call?
Generally, it would be the first contact attempt would be in writing, sent to the address.
And then followed by a phone call?
Yes. So, in essence, if the phone call occurs within the preceding days, sometimes that may beat the mail, essentially.
Yes. Can I ask the operator to take us to Exhibit 665, which is MGR.0005.0001.0081? And this is a document titled Treatment Process and dated the 8th of December 2017. Mr. Ross, can I ask you to explain what this document demonstrates?
Essentially lays out different contact treatment processes that will get assigned based on some internal scoring that may be applied to the customer record.
And what is that internal scoring?
It's based on, I guess, past behaviour that we've observed and some analytics that's run over the portfolio.
And does that dictate, in a sense, the next steps that follow?
Yes.
And so, am I right in saying that if you're on score 1, you travel down that path?
Score A.
Yes. Oh,
Yes.
sorry, score A, my apologies.
Yes.
Can I ask what phone action and SMS action mean?
Yeah, so phone action is involving outbound contact attempts, and SMS action is the sending of a SMS message or text message.
And where do they fit in the process? Where do phone actions and SMS actions fit in the process?
Yeah, so in this instance, as you can see, the phone action will effectively take place periodically throughout I guess the time period that the account is active with us.
So you might be score A travelling down that path and then divert to phone action or SMS action?
No, essentially they run in tandem with each other. So phone activity, the sending of a letter and potentially SMS activity can occur. I guess as you can see there where it says SMS action, for example, it's suggesting that the first time an SMS might be issued is on day 3. In some instances for phone action, you can see that phone action potentially is initiated at day 1. And likewise for scores A through to a no score account, there's representation there about the first effectively demand letter being sent.
So these processes are in parallel?
Yes.
So you might be on score A and also having phone action and SMS action?
Yes, at intervals that are spaced in terms of aligned with our debt collection guidelines.
And do those scores correspond at all to client?
This would be effectively applicable to, say, a DHS portfolio.
Okay, so you would have a score within the context of a particular client,
That's correct.
and which would mean, am I right in saying that that would mean that this would have been approved by DHS?
I can't confirm, but it may have been.
Okay. And so to take, for example, score A, there's contact on day 1. That's right.
Yes,
And 11,
yes,
and 25,
yes,
and 39,
yes,
and 54.
yes.
And there's phone action every day?
If the account meets the criteria to be selected for phone action, yes.
And that's every day until contact is made?
Yes,
And what's contact?
is where we have contact with the relevant debtor.
And so that would be them answering and you having a discussion?
Yes. And or what we also determine as a contact being a message or an answer machine where we leave a message.
So something responsive?
Yes.
And so once you've had contact made, then you have phone action 3 days later?
If there is no resolution through that contact, it would potentially get picked up again for further phone contact activity.
And how long does that go for?
Generally through the time frame that we've got an account active with us.
And when you say account active, does that mean until the debt is settled
Or resolved, yes.
or resolved? And to go to SMS action, you'd also have an SMS on day 3
Yes.
and every Saturday?
Potentially, yes. If there was a mobile number for the customer and depending on the number of contacts that had occurred in the week or the month to align with our debt collection guidelines.
Okay. And so the scores indicate the demand letters, and then there's also separate tracks for other forms of communication by text message or telephone call.
Yeah.
And they're all happening at the same time.
Yeah.
And it might be useful at this point to provide some examples of demand letters, which would correlate to that treatment process. And so if I can go to the document numbered MGR.0004.0001.0121, which is Exhibit 599. This is identified on page 10 of your statement as the first demand. And if I could call up the 2 dot points and the sentence that follows. My apologies, and the sentence that precedes this action may include. If I could call up the sentence before this action may include. Thank you. So I see the words, if you fail to pay this debt promptly, the Department of Human Services may consider further recovery action. Is that right, Mr. Ross?
Yes. Yes.
And that action might include garnishee action or legal action?
Yes.
And there is a request for the payment to be made immediately, with immediately in bold.
Yes.
And that's the first demand?
I believe that to be, yes.
Mr. Ross, if you can't identify it, I can take you to your statement where that's identified as the first demand.
I'm confident it is.
And I'll take you now to the second demand. And the document ID is MGR.0004.0001.0135, which is Exhibit 605. Oh, my apologies, it's 606. And if you could call up from the words repeated to sincerely, that should capture everything. Mr. Ross, I'm just going to read that, and if you disagree, let me know. But the words are, repeated efforts to finalise this matter amicably have been made without success. The Department of Human Services insists that your Centrelink debt be pursued to a prompt conclusion unless we receive payment of the amount or are contacted by you to discuss the situation. We will be compelled to assume that it is not your intention to settle this and will proceed as instructed. And those are the words you can see, Mr. Ross?
Yes.
And that's the second demand letter?
Yes.
And that would be approved by DHS?
Yes.
And can I take you now to the third demand letter, which is Exhibit 586?
The Royal Commission is now in session. Please be seated.
All right, we're at the third demand letter, which is Exhibit 586.
Thank you, Commissioner. If I could call up the document ending 0068. Thank you. And I would just like to call out the body of that correspondence. So you'll see the words, "You've ignored prior communications. As a result, your debt has now been escalated." Is that right, Mr. Ross?
Yes.
"And unless we receive full payment immediately or are contacted by you to discuss your financial situation, we will be compelled to assume that it is not your intention to settle this debt and will proceed with further recovery actions." Do you agree, Mr. Ross?
Yes.
And that those actions include garnishee action and legal action.
Yes.
And again, unsurprisingly, or I should ask, this is correspondence that would have been approved by DHS.
To the best of my knowledge, yes, I believe it would have been.
And I'll take you to the final demand letter, and that's the last of the letters.
Can I just ask, would it mean that your debt has now been escalated within this office?
Essentially, it had obviously progressed further down the collections path without any engagement. And essentially,
Well, you're all just a bit further along.
yes, essentially.
Nobody different was dealing with it, or there was no sort of hierarchy within the office that it was being pushed up?
No, it would still be managed within the same team, but just progressed further in
Okay,
terms of the treatment path.
right. Thank you.
The final of the letters that I'll take you to is exhibit number 594, document ID MGR.0004.0001.0113. And again, I will ask for the body of that letter up until the end of the second bullet point to be called up. And Mr. Ross, would you agree that the same action is threatened, which is garnishee action or legal action?
The same consequences for non-payment, yes.
Yes. And that the first sentence reads, "Repeated efforts to resolve this matter amicably have been without success. The Department of Human Services has instructed us to proceed immediately and insist that your debt be pursued to a prompt conclusion."
Yes.
Thank you, Mr. Ross. I'd like to take you now to a few key changes to the process that you've identified, that were identified in your statement. And the first is identified in the words of your statement, which is the document numbered .0002_R and exhibit 521. And if I could go to to page 8 rather. And at the bottom of that page, if I could extract the paragraph and the italicised text. which is an excerpt from the Centrelink training guide in January of 2017. And Mr. Ross, you'll recall this because it's in your statement, but can you confirm that those words were the words used in response to a dispute being raised?
Generally, yes, to the best of an operator's ability to obviously convey that message.
And that message is to say that the debt is still legally recoverable?
Yes.
And does that mean that, as at that time, even if a dispute was raised, your instructions were to continue to pursue it?
To attempt to set up an arrangement or receive payment of the matter, yes.
But at that time, it wasn't to put the debt on hold?
No.
And that did change? And that changed shortly after that
That's correct.
point in time, and it changed in February, in fact, of that year.
Do you remember a little media attention before that to the whole system?
Yes.
And in page 9 of your statement, you identify in the first paragraph that a practice was adopted whereby a 14-day hold would be put.
Yes, that's correct. In the event that a customer wished to have a dispute in regards to the particular invoice or debt.
But prior to that period, your instructions were to proceed irrespective of a customer raising a dispute.
And to try and set up some form of payment plan with the customer, yes.
Yes.
Well, you were aware quite a lot of these people were hearing about their alleged debt for the first time from your staff?
Sorry, myself personally at the time. As I wasn't, I guess, working and privy to working on the DHS contract
Okay,
during that particular course of time.
right. But are you aware now that a number of people knew nothing of the debt because perhaps they'd moved away from their home, they weren't at the same address? So the first thing that hit them was, in your case, a letter, I think it was.
Yes.
Was there any adjustment to allow for that, that this was the first contact for them about the debt at all? Was it considered that this was an issue?
Well, I think, I guess for us, if we go back through some course of events that I think I've outlined in my statement, you'll notice that on the very early in January, I think it was the 2nd or 3rd of January, we were instructed to put those matters on hold.
Yes, and that's when the media attention is acute, is that right?
Yeah, I believe it was probably through that Christmas period, potentially in December, and then into, obviously continued into January and beyond.
Well, I suppose that might be an adjustment to allow for people hearing about it for the first time, but in actual process, there was no accommodation of that, no consideration of that, it doesn't seem?
Well, again, I think referring back to my statement, there were some communications coming through from DHS in late December, or in December, sorry, which did obviously alert us, or give us information for which we could pass on to DHS customers should they have queries in regards to the particular debts.
So, and how does that help if you're talking to a very shocked person?
Well, offering a contact number for them to call DHS and potentially even warm transfer them so that they can discuss the matter with DHS.
All right, thank you.
Mr. Ross, I might take you to that point in January of 2017 when you were instructed to cease action on certain accounts.
Yes.
And that's referred to in page 20 of your statement. And an event identified as at the 3rd of January 2017 is the instruction to cease all action on certain account codes, which are ISA, ICA and IPA debts.
That's correct.
And are they robo-debts?
We believe that there would have been, if not all of them, a component of those would be.
And were those instructions were from DHS?
That's correct.
And did they explain to you why they issued those instructions?
Look, I don't recall whether there's any specifics in the communications that have been received, but not from my recollection.
And the next item is from 10th of January 2017, which is that IEA debts were suspended. Is that another category of debt that might be a robo-debt?
I believe that could be the case.
And then the next item is the 11th of January. And those codes are identified again, and an instruction to continue suspension of outbound recovery activities for all debts until further notice.
Yes.
And again, there's no explanation for that.
Not that I'm aware of.
Okay. And do you have any indication of how many, was that a substantial proportion of debts that were suspended?
I couldn't probably confirm in terms of, at that point in time, how many of these particular matters were a part of, all active matters for the DHS.
Is
What's
that fairly
ISA
unusual?
stand for, do you know?
No, I couldn't recall straight off the top of my head. I believe that it is referred to in my statement.
Okay, I'll look for it. Thank you.
And is it fairly unusual?
Excuse me?
Is it fairly unusual to have a bulk recall in that way?
Yes. I guess in terms of suspension or ceasing of action, it's not common for clients to do that. Where we would typically see maybe such a cessation would be, more recently would be a natural disaster type event where we might put some matters on hold or all matters on hold for a client. But it's not common for clients, or from my understanding in terms of what I've been privy to, for the DHS to have put matters on hold.
Are you aware of any other occasion when that happened?
For the DHS?
Yes.
No.
Can I call out the event of the 1st of February 2017? And this is the bulk recall. What does that in effect mean?
Essentially for what we refer to as invoices, or the ISA classed invoices that were active with us, the DHS commenced closing those and instructing us to close those files and effectively recalling those matters back in-house.
And you identify in the third column, which otherwise identifies documents, that you no longer have a record of that communication because it's been provided by a secure email portal. Can you explain the secure email portal to me?
Yeah, so through the DHS has provided us a secure email portal whereby communications can be exchanged. The portal itself doesn't provide much memory space, so in terms of being able to go back and retrieve that information for the purposes of supporting the notice, we were unable to do so.
Okay. And the next event that I wanted to take you to is on page 14 of the statement, which is shortly after chronologically in March of 2017. It's the first item under letters. And the change here is that information about debt support services was provided, would that have been an instruction from DHS?
As per that rationale, I believe it was a combination of feedback from DHS as well as Milton Graham.
And so is that because your own people were identifying the need to provide information about support services?
We felt potentially, yes, but I can't comment because I haven't been able to discuss in terms of that with the particular people who are involved because they no longer work with our...
In any event, someone from Milton Graham will raise that as well?
Yes.
Okay.
I didn't find ISA. Do you happen to know, Ms Marsh,
Sorry, Commissioner, I didn't hear.
what ISA stands for?
I don't happen to know what ISA stands for. I've only seen the acronym.
All right, thank you.
But it might be that we can make some further inquiries and provide some more fulsome information. Are those, well, I wonder if this might assist. ISA, ICA, IPA, IEA, are those acronyms or are they codes?
I believe they are acronyms.
They are acronyms, okay.
In the absence of them being acronyms, they're codes that are provided to us to define particular, matters that are owing to the DHS.
Yes, I understand. We might be able to make further inquiries. Mr Ross, in anticipation of giving your evidence today, do you recall being asked by the solicitors assisting the Royal Commission to listen to some call transcripts?
Yes.
And they were
Listen to a transcript.
No, thank you, Commissioner. To listen to some call recordings.
Yes.
That's much more sensible. And did you listen to those?
Yes.
When did you listen to those?
I listened to them yesterday evening, as well as I think it was late last week.
Thank you, Mr Ross. I will then read to you from some of them and ask if you recall some of the words that I am using. Because I have a transcript.
Does anybody else have a copy? Mr McMillan's looking a bit doubtful.
Those haven't been provided as far as I'm aware, but
They should be, shouldn't they?
Yes, they should. The words, nonetheless, are those words that have been transcribed. Commissioner, are you content for me to read those and ask if Mr Ross recalls?
I think Mr McMillan needs a transcript so he can see the context.
Okay. Well, would it be appropriate?
Sorry, I shouldn't talk for you, Mr McMillan, but...
Thank you, Commissioner.
Would it be appropriate to take a brief adjournment so that those can be provided?
Yes, and I wouldn't mind a copy too. Thank you.
All rise. The Commission stands adjourned for a short break. Royal Commission is now in session. Please be seated.
Yes, Ms Marsh.
Thank you, Commissioner. Mr McMillan and I have spoken, and I don't mean to put words in his mouth, but my summary of our discussions are that on the basis that those recordings are themselves tendered, but because they disclose some distressing information and, in a sense, are recordings of individuals who we haven't been able to, in the time available, identify and seek consent to play that material, the proposed workaround is for me to read some passages. Now, those passages have been provided to Mr McMillan and he's content for me to proceed in that way.
Sure, we don't want to play recordings of people who have no idea that those recordings even exist, probably, let alone have given any sort of consent. But you just want to rely on the substance of some of the conversations.
Thank you, Commissioner. That material, Mr Ross, has now been provided to you, and Mr McMillan will have an opportunity, it goes without saying, to re-examine if he considers it appropriate to do so.
And Mr Ross, I think you said before you'd actually listened to these recordings yourself.
Yeah, that's correct.
Okay.
So the first that I'll read to you from is from the file mgr.0004.0001.054, and I'll confirm the exhibit number for that. Zero five.
I'm sorry, Commissioner, that's not one of the transcripts that my learned friend has given me, so I might just ask her to read the last 4 digits of the ID number again, in case it was my mistake.
Mr McMillan, it was .0547.
Thank you.
Got it?
Yes.
All right. Do I have it?
Yes, Commissioner, I understand you have copies of
Where do I find them?
the transcripts that I have.
Okay, I'll look at it.
Commissioner, you could have my...
I understand that I, in fact, have your copy. I was just not aware that they were in my bundle. My apologies.
Have you got a copy? Miss Marsh?
I have a copy now.
Everyone's
Everyone's got a copy, I think.
Right. Thank you.
And the exhibit of the correlative recording is 707.
Thank you. So what's to happen with the exhibit? A non-publication order, or what's the proposal?
Yes. That hasn't been proposed.
Sorry, I'll put my glasses on so I can see
I might
what
have a view on that.
Commissioner, we hadn't made a specific application in respect of the recordings as in their entirety. Our application for non-publication was in respect of the customer's name and the employee's name from Milton Graham. But given the nature of the recordings, it may be appropriate that the entire recordings be subject of a non-publication order.
What do you say about that, Ms Marsh? I don't know about even de-identified, whether it might be a bit distressing for the persons concerned, but what's your submission? What do you want to happen?
Well, Commissioner, as those people haven't as yet been identified and we've been unable to contact them, it might be...
Look, I'll make a non-publication order for the moment in entirety. Oh, sorry, Ms
Commissioner, I submit that you make it until further order if the people who are captured by the recordings and the transcript are identified and want consent to their names or aspects of it being further revealed for the purposes of transparency, then a variation could be made.
I think that...
Well, for the time being, non-publication. Thanks.
Thank you, Commissioner. So the operator states, I'm calling today in regards to a Centrelink debt under your name, and the amount is... And the customer says, I haven't used it for over a year and a half, so I don't know what that would be. The operator says, in regards to a youth allowance for job seekers, the benefits that you were on, so the incorrect the next words are indecipherable, was paid, and further words were indecipherable. So that's why they ended up double paying you this amount. The customer says, okay, so what do you want me to do? The operator says, so the amount is, and an amount is provided in excess of $7,000. The customer states that I owe you apparently. The recipient states yes, but my apologies, the call operator states yes to Centrelink, so they have forwarded the file to us for debt recovery, this amount. The customer states, oh, okay, yeah, they got that wrong. I wasn't even collecting off them. The operator states, but any chance you have checked your MyGov account recently? The customer states, no, I don't have anything to do with it. I'm not even in the country. Mr. Ross, does that broadly correspond to a recording you've listened to and what you see before you?
Yes.
And that is the experience that many had, which was that they were taken by surprise by a call from Whelan?
I couldn't confirm, but yes, that is possible.
But you are aware that some had that experience?
Yes.
Would you describe it as a theme in some of the call recordings that you've reflected upon?
In terms of some of those calls, yes.
Okay. The next of the documents before you that I will read from ends .0573 and the exhibit number is 708 for the correlative call recording. A call operator says, thank you for verifying your details. This is in relation to a Centrelink debt of over $1,000 for the sickness allowance that you received and the incorrect earnings that led towards the automated, and there's some indecipherable words, payment. The customer says, I have no idea what you're talking about. The operator says, a Centrelink debt, did you ever receive a sickness allowance? The customer says, I did, but I never received a Centrelink debt. The operator says, sorry. The customer says, I never received. So yes, I've received sickness benefits when I wasn't working because I had an illness, but I never received information about a debt. The caller says, never got access to MyGov account. The customer says, yep. The call operator says, on the 20th of March, they sent you a letter to your MyGov account advising you of the debt that has been put under your name. Because of no contact, it has been escalated us for collection. The customer says, that's ridiculous. The operator says, you can obviously contact it and discuss it with them, but payment needs to be made. The customer says, I haven't received any information. I haven't received Centrelink since 2017 and it's now 2019. The operator says you can call them and discuss the matter with them and inquire which area you received. There's some indecipherable words and for what and what it's for. And obviously they will give you more clarification and more insight into it. The customer says, okay. The call operator says, and once you've spoken to them, you will need to finalise it. So I'll give you 3 weeks' time from here to make the payment in full. The customer says, well, there's no way I'm making the payment, I'll tell you that much. The operator says, if you're not willing to put an amount towards the debt, then there might be consequences of garnishing of income payments, a travel ban or legal action. And the customer says, I haven't heard from Centrelink. I haven't got a letter. I haven't got an email. I haven't got anything. And the final...
You heard that call?
Yes.
The final question that I have in respect of that is whether that is consistent with the theme that we were referring to before.
Yes.
And so can I take from that that it doesn't surprise you to hear that interaction?
Look, I guess in the course of, you mean today, rereading that versus having heard the calls?
Having reflected upon some of those phone calls.
Yes.
Thank you. The last transcript that I will read to you from is a transcript which correlates to document ID MGR.0001.0450, which is the call recording, which is exhibit number 705. And I'll only read an excerpt from that on page 2. The customer says, "I refuse to pay that. I want to know more about why that's there. I'm literally homeless at this point. I'm couch surfing. I barely have to eat and all that. I've explained this multiple times. I feel very bad about another figure. I've been trying
Well, just to put that in context, he says an amount around $180, and when the call starts, he thinks it's about a $180-odd debt, and then the call operator tells him it's more like $1,400.
Thank you, Commissioner. The quote finishes, "I've had 2 declines. This is information I've already given them. So I'm going through again, trying to get the claim reassessed, and I just don't get where this further figure has been added." Is that consistent with some of the calls that you've heard?
That component, yeah.
Thank you, Mr. Ross. And consistent with the Commissioner's remarks, that's another example of somebody who didn't anticipate to hear from a debt collector.
Correct.
Thank you, Mr. Ross.
What proportion of people did seem to expect to hear from a debt collector? Do you know? How many were taken by surprise?
Look, I couldn't tell you off the top of my head, but I mean, yeah, look, I honestly, I probably couldn't say. You know, I assume that there would be a portion of people whom we did contact who would have potentially received a notification, you know, to ask them to check their MyGov account, potentially received communication from the DHS, but I couldn't give you a figure, sorry.
Because your
Percentage.
debt collection arrangements only applied to people who were no longer on Centrelink, is that?
Yeah, that's correct.
So they'd all been offered for, you know, maybe a short time or maybe a long time.
Yes, that is the potential, correct.
All right.
Thank you, Commissioner. I have no further questions for Mr. Ross.
Thanks. Oh, I'm sorry, Ms Hogendoren. And you know, I forgot to ask the Commonwealth when Mr Whelan gave evidence if they had anything to ask. But Mr Glover didn't leap to his feet, so I'm assuming that it was okay with him.
Mr Glover did not have any questions for the Commonwealth, but I have just one question by way of clarification for this witness. So you gave some evidence earlier concerning the general instructions from DHS regarding the approach to the recovery of debts, and you did that by reference to some acronyms. Do you recall
Yes.
that evidence?
Yeah.
And in your statement from about page 19 on, which I believe is Exhibit 520, MGR 9999.0001.0002_R, you refer at times to having you record an event in a table to provide additional context to those instructions. And in that table, we can see at various points the acronyms ISA, ICA, IPA and IEA. I think you were having some trouble recollecting what those acronyms
Yes, sorry.
stood for. Would it assist you that Separately, an evidence, I understand, which is the response to NTG 5 by the Proper Officer of Services Australia at paragraph 2.29, that the acronym ISA stands for Income Earnings Self, the acronym IPA stands for Incorrect Earnings Partner, the acronym ICA, Income Combined Assessment, brackets Customer Partner, and IEA, Income Earnings Automatic. So that ISA is when there's an individual's earnings is the subject of the debt collection, one where the incorrect earnings based on the partner separately, or one that where it is a combined assessment that has given rise to the debt, and then otherwise an income earnings automatic. Does that assist you in recollecting that that's what you gave?
Yeah, I believe.
Put in your
I
table?
think you'd be correct.
All right.
Wasn't in Mr Ross's statement?
I haven't been specific in terms of seeing that particular document. I don't believe that you referenced, but I have no concern. I believe the ISA acronym or explanation you provided sounds very similar to, from what I understand to be correct.
So just to confirm that, in your table that's in this statement, those are the acronyms that are used. Is that how we ought understand, or you believe we ought understand, that that's what those acronyms mean?
Yes.
All right, thank you.
Thank you.
Right, Mr Macmillan.
Thank you, Commissioner. Could I ask, please, for Exhibit 665, MGR.005.0001.0081 to be shown?
What is it, Mr Macmillan?
That's the treatment process flowchart, Commissioner. Mr Ross, you recall being asked some questions by Council Assisting about this flowchart earlier.
Yes.
You recall Council Assisting suggesting to you words to the effect of it's possible that each of these score flowcharts might be occurring in terms of letters being sent simultaneously with either phone action or SMS action occurring.
Yes.
Yes. Can I ask you, in terms of that flowchart or that workflow of the debt collection process, does that process stop at the point at which actual contact is made by Milton Graham with the customer?
In the event that contact is made with a customer and an alternate course of action or resolution path is established, then yes.
So prior to 24 February 2017, the stop point would have been the customer either paying the debt in full or entering into a payment arrangement for the debt?
Sorry, what was that date?
Prior to the 24th of February 2017, where that change occurred that you gave some evidence about earlier.
Yes.
The stop point would have been the customer either paying the debt in full or entering into a payment arrangement to repay the debt.
Yes.
And after that, the additional stop point was the customer asserting a dispute about the debt or claiming that they didn't owe the debt, and that would be then referred back to DHS for investigation.
Yes.
So in terms of this flowchart process, once Milton Graham had established contact with a customer and one of those three stop points had been entered into, should they have continued to receive letters or SMSs or phone calls from Milton Graham?
No, not until such time as that particular, either the course of action was completed, in which case there would be no need for further action. Now, where I refer to that is in the event of a dispute, for example, the DHS may have reviewed the particular matter and made a decision to recall the account, at which case they would have notified us of that recall and we would have closed the matter and no longer taken any further action in regards to it. But I'd also like to just probably point out again in terms of that, the timing is that the DHS had instructed us to stop all outbound activity and cease action on these particular debts on the 3rd of January 2017.
Yes, thank you. And in terms of, you mentioned DHS recalling the debt, aside from the circumstance where DHS might have determined that the customer either didn't owe the debt or it wasn't an accurately recorded debt, is there any other circumstance in which DHS would routinely recall debts? Was there a time frame in which they would routinely do that?
Yeah, that's correct. So generally after 180 days, if there wasn't a payment received from a customer in the prior 90-day period, that would enact a trigger of an automatic recall from us.
Thank you. Those are my questions. Thank you, Commissioner.
Thank you. Ms Marsh?
I just have one question about the treatment process. Is that consistent with the treatment processes that otherwise apply before that period of time?
This particular treatment path that we went through, yes.
Thank you.
Probably not too dissimilar.
Thank you, Mr Ross. Commissioner, I did have one further matter of housekeeping, which is exhibit numbers, which have plagued us.
Okay, but what about Mr Ross?
Well, the only reason I raise it in the presence of Mr Ross is because Mr Macmillan might have a view, which is simply for me to say that I seek only to tender the documents referred to in Mr Ross's statement or otherwise produced, and that takes us to exhibit number 710 in the current list, and I had inadvertently provided as the end number 712 earlier.
So it should be 710, not 712.
Yes,
Let me just look at what they are.
Could I inquire, does that mean that what was 711 and 712 has not actually been tendered or has been withdrawn from tender?
Those documents
Oh, they belong to someone else.
are not in respect of this witness.
You went a little too far.
Yes, we
All
were,
right.
we were enthusiastic, but we will
Look,
speak to Mr Bureau.
They're tendered. Why don't we just leave them there and just somebody make a note for Monday, if that's when he's being called, that those things have already been tendered?
Thank you, Commissioner. In that case, then the final number for the week will be 830.
Oh, why?
Oh, my apologies. Those are the documents that are referred to, but if it's convenient...
Look, it's
then-
just you had
I
said that
understand,
711 and
of course.
712 were tendered. I'd received them. I don't see any reason to...
Thank you, Commissioner. Up to 7 to 12.
Did you have a view, Mr Macmillan?
No, Commissioner.
Good idea, Mr
Thank you,
Macmillan.
Commissioner.
Commissioner, it affects my client. 711 and 712 are the
does
notice to
it
give
bother
and a
you
response.
if they're in evidence in advance of the witness being here?
No, it doesn't. And if it's of assistance, I did indicate earlier that we had no objections in relation to the balance of the documents referred to in that statement, which indeed means all of that material could come in if that's of any assistance to get ahead of the game. Which would mean that draft list could then be closed out.
Do you want to do that? All right, we'll do it. Let's do it. I will receive as exhibits everything up to 830. That's right, isn't it?
Yes, Commissioner.
Towards with-
830 is the final number.
Okay, all exhibits now. Right, thank you. We will adjourn till 10 o'clock on Monday.
I'm sorry, Commissioner, would you excuse Mr Ross?
Oh, I hadn't done that yet. I was going to ask you, Ms Marsh, do you wish Mr Ross excused? You're excused. Thanks, Mr Ross. Adjourned.
Thank you.
All rise. The Commission stands adjourned until 10 a.m. on Monday morning.